such effort or initiative as it would adversely impact the property rights of owners and contract purchasers of the property. Thank you.
All right, thank you for your comments. Next speaker, please.
Next speaker, Rodney Bracy, followed by Kathleen Corbett.
Good morning. My name is Rodney Bracy. I'm the co-owner of National Construction and Consultant, LLC. I'm a certified disabled veteran and a state licensed general contractor. On 1st November 2023, I was identified as the low bidder for the project on Y24-719, which is the 37th Street project sidewalk. On March the 14th, we were deemed non-responsive for non-conforming licenseship and removed from the low bid list. I repeatedly tried to reach the Orange County procurement without any answers. On January the 12th, 2024, Mr. Mello finally reached out to me. He is the contract manager for that project. And by email, he assured me that if he had any questions, he would reach out to me, and if he had any questions, he would reach out to me himself. I never received any notification from Orange County Procurement about this project, so I assumed that everything with my bid was okay. March 14th, this project was given to another contractor for over $300,000 more than what my bid was, and $301,000 over Orange County's estimate. I'm asking the board today to not approve this contract and to find out what happened with the county reaching out to me for additional information, and to find out why the process of the procurement department did not, why they're paying somebody $300,000 more to do the same job that I'm qualified to do. Thank you very much.
All right, thank you. I'm going to have the county administrator take a look at this with the appropriate staff, and you all can report back to us on that. Next speaker, please.
Thank you, sir.
Next speaker is Kathleen Corbett, followed by Eugene Staccardo.
Hi, my name is Kathleen Corbett. I live at 118 East 8th Street in Chuliota. I'm not a good public speaker, but I like my green. And you're expanding over Winter Garden, everywhere else. Keep our side green. Out to the beach. That's all I ask. Thank you.
All right, thank you for your comments. Next speaker, please.
Next speaker is Eugene. Following Eugene will be Kelly Simrat.
Good morning, Eugene Staccardo. I'm representing myself because I'm on the CRC, so I'm only representing what I think. 331 Roswell Avenue. Please vote yes on the removal of the Lake Pickett study area. We've worked over 12 meetings in the CRC on the sustainability of the rural boundary charter amendment. We've put in over 20 hours, and it's 6 of us, 4 of which are attorneys, plus our counsel. So it's been a lot of conversation about this, a lot of details in that rural amendment. So why is the rural boundary that we're studying uses the Vision 2050 maps? By Seminole County giving us the vision of what they had done using maps that they developed over 2 years, I decided to propose to use our maps, which are been worked on for about 7 years now. And this is why we needed to make sure these maps are fully updated prior to this, and make sure the Lake Pickett is removed. The rural boundary charter will be a tool, and if it's approved by the CRC, then the voters, and finally, because of our beloved preemption of legislature, you, the BCC. It will allow a better control for annexations using the power of the as a charter county to control land use based on each annexation proposal within the rule of what we have written in the charter. It will also offer a better control of rural cities aggressively, unsustainably annexing just on the whim. Please, we need to make this right, the map's correct. So, thank you. Good day.
All right, thank you for your comments. We'll move to the next speaker.
Following Kelly is Kathy Glover.
Thank you. Good morning, Mayor and Commissioners. My name is Dr. Kelly Semrat. I reside at 3111 Amalfi Drive. Today I'm asking that you vote in support of the motion to remove Lake Pickett South as well as the Lake Pickett North, as well as the associated parcels that are within the Lake Pickett study area that have not been commissioned for growth. Vision 2050 recognizes those parcels as an intended growth sector. The county now has more data than it's ever had from its constituents advocating against this development. We have a legal ruling from a local judge saying that this was urban sprawl. Sure, Governor Scott overturned it, but we have a judge who said that it was urban sprawl. We have a deficit in our roadway funding that we're proposing to raise taxes on to try to cover and to fix the issues with our roads. This is suburban sprawl at its finest. Lake Pickett North, Sustany, the applicant's attorney was here. We're not taking away property rights by removing them. No, we're protecting them. It's agricultural land still today. It has not been rezoned. This applicant has had more than a decade to get his plan together to get a commission to vote in support of it. This board didn't vote for it, the board before it did not vote for it, and the board before that did not vote for it. We've thrown a seasoned politician out of office. We sued the county. We won in court. In a time of diversity and despair in this world where we are so divided, East Orange County has remained united. We are still here. We're still fighting, and we're still begging you to help us. Vision 2050 is a kick in the gut and a slap in the face to East Orange County residents by labeling that as an intended growth. What has the community been fighting then the last decade? This is an insult. We are begging, we are asking, and further, we will continue to demand that Lake Pickett North, Sustany, and the surrounding parcels are removed from the Lake Pickett study area. They should not be getting preferential treatment where this board holds a pocket of land available for them to develop. Please support our commissioner. Thank you.
All right, thank you for your comments. And as usual, during our proceedings, there should not be clapping, etc. Okay. All right, next speaker, please.
Next speaker is Kathy Glover, followed by Lee Perry.
Okay, good morning, everyone.
Good morning.
I'm here to support Emily Bernita and all of us in East Orange County, Save Orange County. My address is 827 Lockwood Drive, Orlando 32833. I don't have a whole lot to say because we've been saying it since 2013, but I'm just here to support everybody here. Thank
Okay,
you.
give us your name, please.
Oh, Kathy Glover. Sorry,
All right, thank you.
I always give up my minutes.
All right, thank you very much. We'll move to the next speaker.
No, there's no minutes.
Hi, everyone. Good morning.
Good
I actually
morning.
have a little thingy to show and pass out as well, if that's okay. All right. Good morning. My name is Lee Perry. I reside at 2008 Corina Drive, Orlando, Florida, 32810. And I am here to speak on Split Oak Forest and against the Sunbridge annexation. First, I'd like to say congratulations on your lawsuit win using our tax dollars to defend Split Oak Forest and the language in our charter. I want to respond to the false narrative that there's nothing Orange County can do to defend Split Oak. They quoted the mayor saying in the Sentinel, saying that all the stars aligned for the toll road, which really means all the corruption of Tavistock is actually falling into place using our system for their profitable gain. There are 4 things I'd like to point that Orange County can do right now to show solidarity with the Save Split Oak Forest movement. 1, show up to the May 1st FWC meeting, asking them not to revoke their responsibility over the parcels of our environmental easements. 2, officially rescind the application from 2019 to FCT. 3, do a rigorous environmental study from a non-conflicted biologist and request a mitigation plan. And 4, have meetings with us, more than you meet with Tavistock. You all have my personal cell written down. I'd love to meet with every single one of you. And as for Sunbridge, we see the writing on the wall. This is a map upside down of how much land the Mormon Church owns, how much land the Mormon Church owns, and the orange is Desert Ranch. We see how much sprawl is coming. That's hundreds of thousands of acres and hundreds of thousands of developments and people that are going to be moving where we don't have access to clean drinking water and where our wildlife will be greatly impacted. So I say no to the Sunbridge annexation, and I would love for you all to stand with me and have a meeting with me to discuss why we're against this harmful, expensive sprawl. Thank you.
All right, thank you for your comments. Do we have other speakers?
Next, the last 2 speakers, Lyndon Johnson and Marjorie Holt.
Good morning.
Good morning.
I'm here today to support Ms. Bonilla's efforts to stop this growth that's come to our area. My name is Lyndon Johnson. I live at 14513 Daring Avenue, 32826. I've lived there for over 30 years. And I've seen the growth come in to the area, and I'm concerned about 2 things. I'm concerned about the fragile ecosystem that we have up and down the Ekanlaki River and the creeks that are out there. And I'm also concerned about the infrastructure. Since Avalon Park was built, Colonial Drive has become basically a gridlock every morning for about 2.5 hours. So everyone that leaves that area on their way to work, they have to sit in traffic. I'm very concerned about the ecological impact that all of this is having to our rural properties out there and the wildlife. More and more wildlife is getting struck by cars. And the other thing that I'm concerned about is I live in an area that is, I think it was probably constructed in the 1960s. We still have open ditches on our main thoroughfares. We just recently got a few sidewalks put in after, 50, 60 years. And it just kind of points out the fact that sometimes Orange County doesn't come back and maintain things for the residents that have been there the longest. Thank you so much for your attention.
All right, thank you, Mr. Johnson. Next speaker, please.
Good morning, Mayor
Good
and
morning.
Commissioners. I'm Marjorie Holt at 8502 Elveron Avenue, Orlando, Florida, 32817. And on behalf of the Sierra Club, I submitted a letter yesterday to the City of Orlando, and that's regarding the second phase for the annexation. This map was sent online, and it's part of the letter, but this area right here is where development trudged down 436, and it shows how that movement in a very small corridor can expand. I'd like to express my deep concern that the city is at the eastern boundary and that those lands in the rural service area could be grabbed up. Currently, Orange County provides greater environmental protection through our wetlands ordinance, tree protection. We've got the ELSP that was enacted for the Innovation Way corridor. So appreciate any action you can do to refute this, any conflict resolution that was mentioned yesterday. at the City Council. And my next item is in support of Commissioner Bonilla's discussion and any proposal to remove or deal with the Lake Pickett study area, an area in the rural service area, a master plan community that is a prime example of what not to do. So with that, I thank you.
All right, thank you, Ms. Holt. We'll move to the next speaker, if there are any.
That concludes the speaker list.
All right, to all of the speakers so far today, thank you for your presence and being involved in your local government. We're going to move now to the next item on our agenda, and this is the consent agenda. I'm going to ask the county administrator to present the consent agenda.
Thank you, Mayor. There are 4 items that I want to pull from the consent agenda. The first is item C2 under the county attorney's office. It's a case of land trust, number 2201 SOBT versus Orange County. This item is being pulled at the request of Commissioner Uribe for discussion this morning. The second item is D11 under Administrative Services Department, Contract Y24-2221. This item is being pulled for further review. We'll bring it back at a later date. The third item is G1 under Planning, Environmental, and Development Services. It's regarding the interlocal agreement with the City of Orlando for the Watershed Atlas project. Again, this item is being pulled for additional work and will be brought back at the next board meeting, a future board meeting. And the fourth item is H3 under the Public Works Department. It's a roadway use agreement regarding Schofield Road. This item is being pulled for further review, and we'll bring it back to the Board of County Commissioners as a discussion item in May 2024. And with that, Mayor, staff presents the remainder of the consent agenda for board consideration.
What was the third item? What was the number?
Third item is G1.
G1.
Under PEDS.
Okay. All right. With the exception of the 4 items that have been pulled, is there a motion for approval?
Motion to approve, Scott.
All right, I'll second it. All in favor, let it be known by saying aye.
Wait, but if we're discussing items that are pooled.
We'll come back to those items. This is everything except the items pulled.
Okay. Thanks for the clarification.
Okay. Everything except the items pulled, the 4 items pulled. Okay. We have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. Motion passes, and it is unanimous. And before we go to the discussion agenda items, let me, and those items pulled, let me just make note of the ones that were just approved. The Community and Family Services Department has a number of agenda items today that will benefit the health and well-being of communities across Orange County. Through the Citizens Commission for Children Division, the department entered into a new 3-year, $300,000 contract for nutritional programs for Orange County youth and families. The contract with local nonprofit Comparte Tupan, Inc. will provide nutritional, educational, and hands-on activities, including cooking demonstrations, recipe sharing, grocery shopping, planning, and other things. The agency anticipates serving a minimum of 5,000 residents countywide to deal with food insufficiency issues. The Citizens Commission for Children is also amending an existing contract with Second Harvest Food Bank for a program that provides healthy meals to low-income families. The additional funding will provide approximately 3.8 million pounds of food to Orange County children through the county's summer feeding food distribution events and their school partnership program. Of course, we don't have long yet for the end of the current school year. Additionally, funding would also allow for the expansion of several food distribution efforts, including mobile food distribution sites, pantries, and shelters. An opening in May, the Community Action Division will oversee operations for the Financial Empowerment Center. The center will provide comprehensive financial counseling, including credit and debt management, safe banking, and wealth management. The goal is to assist families in attaining or sustaining financial stability. Habitat for Humanity will provide one-on-one counseling at its offices and at the county's 8 community action centers. And also, Orange County Community Action is entering 4 new licensing agreements, which allows local nonprofit organizations space to provide their services in 3 community action centers. The services include financial counseling, community support and outreach efforts, vocational training, and youth literacy. And also, on the consent agenda, the Parks and Recreation Division is working with the Florida Department of Transportation to expand the West Orange Trail. Today's agenda item seeks funding for the design of that expansion project, which was originally approved within the current fiscal year budget. The project adds 3 miles to the existing 22.5-mile trail, lengthening it to the entrance of the Wekiva Springs State Park, and the expansion project is set to be completed by July of 2027. And so with that, we'll go back now and pick up 3 of the items. Will come back for later board meetings, but the one item that is of note that was pulled by Commissioner Uribe, and I think that was item C2. We'll have a discussion at this time regarding C2. D11, G1, and H3 will come back to the board on a later date. Okay. With that, we can have the conversation. Commissioner Uribe, questions about that item C2?
Yes, thank you, Mayor. I wanted to bring up item C2, and I also wanted to make sure that our colleagues here saw the article in the Sentinel. OBT strip club property owners may regain adult entertainment license based on the vote of the county commissioners today. And I don't know if you guys remember this case, but this is a case, I want to say over a year ago, where 15-year-old minors were enacting in sexual activities at this club. The MBI did an investigation, shut them down, arrested the managers and some of the people involved. And I got to tell you, Commissioner Scott and I have the pleasure of sharing Orange Blossom Trail, but more so than not, I have the pleasure of being born and raised there. And it was a great day when we shut it down and we said, one less of these that are grandfathered in and allowed to be there. But let's talk about the reality. This is horrible for our community. And one, the reason why it was shut down was because of the criminal activity, because it's a non-conforming use. Basically, we don't allow this activity to take place. And for a settlement in a case, we are actually going to give this owner who allowed this activity, whether he knew or not, that's up to the courts to find out, to sit back and open up this establishment that was no good for our community. Over the years, I would love to find out how much criminal activity, how much aggressive activity has taken place on there, and how much of an issue this has been to law enforcement. But more importantly, these are the things we need to fight for. These are the things, when I read the letter from the attorney, they were claiming that the liability was $1.6 million because they don't have the ability to have an adult club there anymore. So they want that value regained. And in this settlement, we're not only settling because we're excited that we're not paying any fees, but we're going to let this business reopen. And how can we sit here and support this non-conforming use? If anybody didn't read the article, basically their ability to run this kind of business was removed and the tax collector is not allowing it. But if we vote today and with the addition that comes in the back, we're basically saying And by the way, criminally, this case is still active. It's not been pursued. But these are the things we fight for. I could not sit here and agree that this is a good thing for our community. I cannot sit here and think this is a win for us because we're allowing this person to be out of business for 1 year, but to come back. And I cannot sit here knowing, this is all we know about criminal activity, the 15-year-old that was found to be doing these activities. But what about the community there? What are we saying for that community? We're willing to fight for all these things. And I agree, Commissioner Bonilla, we want to fight for rural settlement. We want to fight for land. We want to fight for all these things. How about we fight for our community to stop allowing and appearing and agreeing to let this keep taking place? And I hope that we will pursue this. I don't know legally what we're able to do at this point, Byron. I'm going to kind of address it to you. But I don't like the settlement. I don't like what we're taking, the deal we're getting to allow. We're excited that we're not going to have any legal fees. And reading this document, we should be fighting this. We should not be allowing this business to open it up. So basically, they want their non-conforming use to be reopened. And I am not an attorney, but after reading this, reading the document from the lawyer that was presented to the county, basically the value of their land has gone down because it's no longer an adult club. And if $1.6 million is a liability, you know what? We should go and fight. We have fought for a lot. We have allowed a lot more spending in government money, but to sit there and say we're going to go fight to give dignity to this community, to not continue to allow this kind of activity, and to not, what kind of precedent are we saying? You get in trouble at your club, you have sex trafficking, you have youth doing sexual illegal activities, MBI shuts you down, and guess what? Come back a year later, we're going to let you open up for business. And I ask you all to help get behind this and get our legal team to fight this. Fight this for what it is, to fight this, to not allow this business to come back, to not allow a precedent to be set that no matter what you do, we slap you on the hand and you come back a year later to do what you're doing. This is wrong. They did wrong. They violated it. They allowed this to happen. This is why criminally they went. This is why our law enforcement worked so hard to shut them down. And I believe it's a slap in the face to not only this community, but to our law enforcement who fought for this. So while we fight for many things on this board, and I'm proud to be a part of what we fight for the right thing, I ask you to join me and make our county, and ask our county to fight to not allow this to keep moving forward and to not allow this to open up again and do what they were doing and who knows how for our community. Do it for us. Do it for the area and the people we represent. And I'm asking you to vote no on this and ask our legal team to go fight this as hard as they can to not continue to allow this to continue in our community and think that people can get away with this in the future.
All right, I'm going to go to the county attorney, Mr. Newton, or the assistant county attorney. I know Mr. Birnbaum had been working on this case, so I'll start with the county attorney.
Mr. Birnbaum is going to address some of the questions, but as he's heading to the podium, I'd just like to say that we all enjoy a good fight. I know Lee does, and I certainly do, but we enjoy the fight when the facts as well as the law is on our side. And when that's not the case, we have a duty and obligation to inform the board of what the facts and the law are and make recommendations in terms of the particular litigation matter that's in front of the board. And that's what we've done in this particular instance. So at this point, I'm going to ask Mr. Birnbaum, who was very instrumental in negotiating this settlement, which quite frankly, I was very surprised that we were able to negotiate such a settlement that absolved us basically of any potential liability, not just from a financial standpoint, but from the standpoint of the potential proliferation of adult entertainment establishments throughout Orange County in the I-4 and I-4 zone. So, Mr. Birnbaum, would you please address the facts of the case, the fundamental constitutional and issue that exists, which prompted us to enter into, or at least propose this settlement agreement to the Board of County Commissioners?
Yes. Lee Birnbaum, Assistant County Attorney. Thank you, Mayor and Commissioners. Commissioner Uribe, we totally understand the seriousness of the underlying criminal activity. You're right. The charges are still pending against 4 individuals for human trafficking of a minor, of a child under the age of 18. This case, although this case involves those background facts, there is a distinction that we think is very important in the county attorney's office between the operator of the adult establishment and the owner of the land. This lawsuit that we're asking the board to consider and approve is brought by the owner of the land itself, Land Trust number 2201 SOBT. They're the owner of the land. They essentially acted as a landlord. They leased the adult establishment to, at the time, an entity called OC Flash Dancers LLC, which operated flash dancers. The individuals who are charged with those very serious involve the operator of the establishment, the main person that was the managing member, and they're on an ongoing basis of flash dancers, and some employees under him. There's 4 individuals. Those charges are pending. They have been pending for a year. You're right, Commissioner Uribe. It was an investigation by MBI, and they've done that. MBI did not charge the property owner with any criminal activity. We understand that's, of course, a different standard. A big part of the reason, and as county attorney addressed, is the constitutional issues. One of the underlying issues, and one that we think is caused us some concern, is the due process argument. Under our Orange County Code as it currently stands, a license holder of an adult license, which you do need to operate an adult establishment and which the tax collector issues, under Chapter 3, that licensee may or may not be the landowner. In this case, they were not. And so even the head individual was given under our code notice of when the tax collector, due to the criminal violation, suspended and then revoked the license, and they had an opportunity to challenge that. They did not. As our code currently stands, though, and this is the due process argument underpinning a lot of the plaintiff's allegations in this case, the property owner, they of course knew about the revocation, but they didn't get formal notice from the tax collector, and probably more importantly, for purpose of the lawsuit, they were not given the right to challenge pursuant to Chapter 3 of our Orange County Code through a hearing officer that revocation. The problem, as we see it, arises because, in spite of that, the property owner, and it's what you touched on, Commissioner Uribe, their land and use of their property can be implemented by a revocation. In this case, that property owner was not able to operate an adult establishment for 1 year after the revocation, even if it was to a different license holder. And as you correctly indicated, under our code, they lost their non-conforming use. Prior to the criminal allegations and the criminal violations, I think the criminal charges started almost exactly a year ago, maybe a little before. Certainly the investigation was first. So under our code, the property owner never got the right to challenge it. They've now lost that non-conforming use. We are concerned that they didn't have the right to do that. That is the due process, one of the constitutional arguments that County Attorney Newton mentioned that the plaintiff brought that we think poses a risk to the county. Twofold. One, may lead to their argument as to the entitlement to the $1.65 million of damages due to the loss of that business, as well as they were seeking in this lawsuit and are seeking to have a court declare certain provisions of our code to be unconstitutional. One of them is due to the lack of due process they were given by losing the non-conforming use without an opportunity to ever challenge the revocation through our administrative process. The other thing I want to mention briefly that the county attorney touched on, another constitutional argument that they mentioned, Mayor and Commissioners, and that is part of the lawsuit, is they brought a First Amendment challenge arguing that the Orange County Code and our zoning and distance requirements within the Chapter 3, the Adult Entertainment Code, are overly restrictive, and that Orange County does not provide sufficient sites. So while we'll, of course, contesting that, we don't believe that argument is as strong. There's a risk not only on the due process end, which we do think is something that the county benefits by resolving, and a risk and avoid any monetary damages. If the case does not resolve, they're going to continue to challenge those other provisions and try to argue there should be more sites under the First Amendment. And there's a whole body of case law that talks about that. So those are the main reasons that we did recommend and are recommending this. We understand the seriousness of the criminal violations. We understand the negative consequences of adult entertainment establishments, as our code recognizes. In this particular instance, though, we do think it's in the best interest of the county for those reasons.
All right. With that, I want to move to the other commissioners for questions or comments. I'll call them in the order in which they have pressed their button. We'll begin with Commissioner Wilson.
Thank you, Mayor, and thank you, Commissioner, for bringing this out of the consent, because I do think it's an important discussion. And I remember the briefing, and actually, Lee, I want to congratulate you, first of all, on the Split Oak hearing. I can't tell you how many fans you have in the environmental community now.
Thank you.
And I know how hard you all work on making sure that the county is well represented in so many different fronts at one time. So I think my question may go like a step backwards towards zoning and why, as a non-conforming use, we have the why do they continue to protect that as though it were a use that was permitted from the beginning? So to hear that they don't have a remedy almost indicates to me that it was always a conforming use, but it wasn't.
Well, at the time this establishment was originally operating back, and I think it was since at least the 80s at that location, adult entertainment was allowed to operate in commercial zoning. It has since been amended, and it has to be an industrial now. So anyone coming in to try to apply for a new adult license to get issued by the tax collector has to fall within, I think it's the I-4, I-5 industrial zoning now. Because they were lawfully operating at the time those changes went into effect, Commissioner Wilson, they and other sites were grandfathered in. And
So they're using that as their the basis for their due process.
Well, I think that, and again, because they as a non-licensee property owner weren't given any notice, an opportunity to challenge a revocation, even if, for example, they were operating as a lawful conforming use, they would still lose the right to do that for a year. But yes, they are arguing that this is more of a long-term permanent impact for that reason.
And let me add, Commissioner, you saw, if you read the article this morning, that they claimed that the property has no value unless it is operating as an adult entertainment establishment. And that's because these folks are very sophisticated. So there is a restrictive covenant on the land that says its only use could be an adult entertainment establishment. So they try to protect themselves from any potential revocation, if you will, or restrictions that the property could be used on by restricting their property.
Yeah, and I mean, I do think the most troubling part of the settlement is the contingency that a new permit be issued in order for this to even hold.
Well, and again, we didn't talk about that a lot, but yes, the contingency involves, you're right, not only board approval, but their ability, and when I'm saying they, I'm talking about the property owner, but we're probably a different tenant that then applies to the tax collector, who through the tax collector's normal policies and procedures determines if it's issued. And when it gets to the tax collector, the new applicant, they give a lot of information, and the tax collector sends it to, I think, 4 or 5 different entities. MBI does criminal background checks on all the principals within that new tenant, whether it's a person or an entity. We get from zoning to make sure they look at it and make sure there have been no changes and it's still far enough away from schools, residential or otherwise, and otherwise. So yes, they have that ability to, if they don't get that, then the litigation is back open. But, you know, they know what those requirements are. It's certainly not going to be anyone affiliated with OC Flash Dancers or any of the principals involved. It would have to be a whole new entity that passes those criminal and other background checks.
But with no stopgap for, I mean, this is clearly a landlord that hasn't been, well, I was going to say, or has not at the very least seemed to see what was going on underneath his nose as far as illegal and potentially dangerous activity. Just as a hypothetical, what if if they were making meth there?
Well, I don't know the answer, but one thing related to what you're asking that I would point out to you, Commissioner, and the rest of the board, interestingly, and it's slightly off topic, but I think it's relevant.
Yeah, the 6th district case, is that
yes,
what you're going to mention?
There is a recent personal injury premises liability case in Orange County where someone was injured in the club, sued the owner of the property. It's not the current owner. The current owner is a trust, where the trustee is the adult child of the prior owner. But that prior owner and his company was sued for being responsible. The jury found him to be liable, and just 3 weeks ago, the District Court of Appeal, which oversees Orange and Osceola and some other counties, reversed that and indicated that a directed verdict should have been entered in favor of the landlord, a property owner, and specifically said that he lacked sufficient control over the premises and was entitled to a directed verdict. The Sixth Court went on to say the duty to protect third persons from injuries on the premises rests not on legal ownership, but on the right of possession, custody, and control, and that it was the tenant, which in this particular case that I'm reading was OC Flash Dancer LLC, who was responsible for providing security and safety. And in fact, in that case...
So really indemnifying the owners in more than one instance. But that, in particular in that case, I don't know if it came out in the analysis, that's a civil action, whereas this is a fully prosecuted criminal action.
Well, yes, but this case we're asking you to approve settlement is a civil action too. And I'm just bringing up, you rightfully, and Commissioner Uribe rightfully brought up, well, why isn't the owner more aware of what's going on, or the landlord more aware of what's going on the premises? I'm simply indicating a recent case
that allows them to
that involved another civil action and the same standard. Sorry, Jeff.
Which causes us even more concern.
Right, I got you.
And kind of reiterates why the settlement is before you, because of the potential that, as we've already determined, at least the lawyers have already determined, that in this particular instance, given the distinction between the owner of the property and the licensee, the tenant, that we think this is a settlement that, from a legal standpoint, should be entered into. I think we've done the best that we can from a legal standpoint, but if this board feels as if we should, fight on, despite at least from a legal standpoint, the significant risks that exist, not just from a financial standpoint, but also from the potential proliferation. Although we don't put much stock into that argument. That's certainly the board's prerogative.
Well, I mean, my only other question would be if, moving forward, is there any opportunity for us to tie the license to something that requires more landlord oversight? I think there are many instances in code where we require an extra layer of safety protection for a homeowner or a business owner. Is there something we can do so that we don't continue to invite this type of abuse and then sort of the...
Well, I think the first step is the ordinance that is being amended this afternoon, some of the amendments in order to provide notice and opportunity to be heard to the owner. And we can certainly look at any additional protections that we might be able to put in place that would represent sort of like constructive notice to the owner, where the owner is not also the operator of the facility. That's something we'd have to, look at and research and see whether or not there could be some additional protections added to the ordinance.
Okay. Yeah, and can I just briefly add to that, as the county attorney touched on at 2 o'clock today, there's proposed ordinance amending. I will tell you, as part of this lawsuit, there were discussions more by the other side about, hey, this loss of non-conforming use isn't maybe fair to an owner. And we said, no, if we resolve the due process issue, then it's up to you, owner, to be more diligent in the future. But so we think we do close that loophole and put the burden on them once we amend the ordinance.
All right, thank you.
Or if we do. Thank you.
I think there was kind of within that conversation, if you could, you talked about risk, the risk to the board if we didn't settle this. Can you just kind of maybe succinctly say what are those risks? Are they financial risks? I think at some point you even maybe inferred that if we lost, there's a risk somehow of proliferation of other adult entertainment types of establishments perhaps being able to get a foothold into operating. And so kind of, I heard you saying something there that I just want you to clarify if you can.
Yes, sir. Yes, Mr. Mayor. So two or threefold risks. First of all, yes, we do believe it doesn't resolve there's financial risk because their lawsuit involves a claim for money damages, not just a claim to invalidate the code. And it's twofold. One is they're indicating that loss of the non-conforming use without their ability to challenge a revocation is a taking, and so they brought an inverse condemnation claim. They secondarily, and I think this may be what Commissioner Uribe was referring to, they put us on notice of a Burt Harris claim, which essentially says even if the county's actions don't amount to a taking, we think it inordinately burdens or restricts, and that's where that $1.65 million appraisal. So yes, Mayor, we do believe if we don't resolve, there is a very real risk that a court or jury could ultimately find that the county in one way or other improperly limited their use, whether it's for that year or more so they would argue a reduction of income forever being able to have an adult establishment there. So yes, one risk is certainly financial. They also are entitled to make a claim for attorney's fees and costs if you win an inverse condemnation claim or a Burt Harris claim. The second risk is instead of us voluntarily amending our code as we think is proper and appropriate and limiting the scope, there is a risk that a court through injunctive or declaratory relief could found, for example, the parts that don't give an opportunity to challenge to a non-licensee property owner. Court could invalidate that and limit that. They've asked for a whole bunch of Chapter 3 of the Orange County Code, which I refer to as the Adult Entertainment Code or AEC, to be invalidated. So to the extent a court does that, that would restrict our ability and the tax collector's abilities to regulate. And then the proliferation part, Mayor, which I touched on and the county attorney touched on, is, again, candidly, we don't think is as big a risk, but it's a risk. They have also challenged the distance and zoning separations that dictate where within the county adult entertainment establishments can and cannot be located. And our code talks about a certain distance from schools, residential facilities, other adult clubs, as well as some other restrictions. So were a court to find that those are overly restrictive or don't provide enough alternative for First Amendment protected activity, I'm kind of putting that in air quotes, but that is what the Supreme Court says, then that is the possible risk of proliferation of more establishments based on that challenge.
All right. Thank you.
Let me add that proliferation would be significant. We did a mapping with, I think it was Planning Department.
Yes.
And estimated that there might be as many as 200, a minimum of 200 additional locations for adult entertainment establishments. So we, as I said before, we think the legal risks are significant, but it's the board's pleasure in terms of what it would want to do.
All right. Commissioner Scott.
Thank you, Mayor. Lee, thank you. Hey, just so I'm, Lee, where is Flash Dancers located? What district is that?
It's yours. It's District 6, and it's, in fact, exactly at the property address, the name of the land trust, 2201 South Orange Blossom Trail in District 6.
So it is in District 6. All right.
Yes, sir.
So, Commissioner Uribe, you were spot on. Pretty much all of the comments that you shared, I shared with the county attorneys even before we got to the settlement. Beyond that, I've gone to Flash Dancers quite a few times, not inside, but my friend is the barbecue man, and he was shot there, right? Even more, my father, working with the OBT Next Development Board and the Orange County Code Enforcement, worked to reduce the number of adult entertainment establishments from years ago, well over 100, 115, I think it is, to what it is today. If it was up to me, we wouldn't settle. It is up to me and us, rather. But I trust the county attorney and his team, and I don't think we should fight and be involved in litigation for potentially years, because what is clear to me and was clear to me in the briefings is that, the owner of the property has time, money, and resources. And, I think of it to a can of worms. I don't think it's good to settle, but I also recognize that we have to afford due process, especially in instances where we don't agree with someone. Everybody should be afforded due process. And the owner, through his counsel, has articulated several points, and through time could articulate several more where we are lacking in some respects. And so I think, I have full faith and confidence in our county attorney and his team and Lee and the work that they've done. So while I agree with you, I don't think we need any more strip clubs. We want more community centers and just more opportunities for people to grow. I think the facts as presented by our county attorney speaks to what is the prudent course of action. And so I just wanted to share those comments, but I do appreciate you sharing that today. Thank you. No further comments, Mayor.
Commissioner Bonilla.
Yeah, I apologize because I missed the last couple minutes, but I had to send some signed documents before 11. So if this was already covered, I apologize. So was this considered a nuisance property, and did anyone go through the process of saying it's a nuisance property?
Not that, respectfully, I'm not sure exactly what that means, maybe because it's not something I deal with in the litigation. But
Not that I'm aware of, Commissioner.
Yeah.
Not that I'm aware of in terms of it being designated a nuisance property.
Okay, so who is aware of the requirements for that? Because as far as I know, if there's a property that has criminal activity at, it's considered a nuisance property, and
That would be probably the sheriff's office.
okay, but it's under county ordinances. And they enforce
Well,
it.
either code enforcement or it's some other county department or division. I'm not aware, but I'm not aware of this particularly.
Okay, because
I'm sorry, I was just going to add, this case has been going on for a while. Before that, there was a federal court iteration. I've had a lot of contact within our zoning code enforcement. I've never been told that. I think I would have, but I just wanted to add that.
Okay, well, definitely, Commissioner Uribe, I definitely support you in this and understand where you're coming from. I know we don't, it's up to the board if we accept settlements, but is this something that we are allowed to have one of those private meetings so that we could kind of discuss things that we may not want, the other party to listen to?
It's pending litigation, Commissioner. We could have a closed session, but in this particular instance, I didn't think a closed session was necessary because it's really not a strategy-related issue. It's just pretty cut and dry from a constitutional and due process standpoint as far as we are concerned.
Okay, because, I do see that, this is a nuisance property, could fall under that, and this is something maybe we could discuss, in an executive session. So perhaps we can table this and have an executive session to really discuss some of the other options we have for this, rather than just accepting the settlement as is, since it seems like not all of the, things that could be covered.
I'm not sure how it being a public nuisance obviates the due process issue that exists.
I understand that, but I just would rather have that discussion than to accept a settlement that may have the opportunity to maybe be adjusted a little bit, or I don't have all the information, and I know there's other options, and I want to know what those are before I agree to a settlement, because I just don't know if everything's been, thought through. And I just want to make sure before we sign a settlement like this, that may put us in a bad situation.
If we agree to take it further, can we have that meeting? If we agree to want to try to fight this, as opposed to just settle and take what they're giving us?
Well, you can't make that. You have to make that decision in an open forum. If you,
Okay.
I wouldn't be able to make that decision in a closed meeting with the board. We'd have to come back out. We could, and
So I guess we need to
have
find
that
out-
discussion.
I really
but
think
hold on,
the fact of the
just a
matter is,
second, just a second.
I don't see how
do a
that discussion, that closed door meeting, is going to be beneficial in terms of the issue that is problematic from a legal standpoint. It's just not going to resolve that.
Just for a point of clarity, is there a timing issue related to making a decision that problematic for the courts. You obviously, we have the pending litigation and we have to make some decisions. I don't know if there's a pending court hearing or anything that makes this more of an urgent matter, or if not, if it was the will of the board to pause and have a closed session that was very narrowly focused. Obviously, that we'd have to take the direction of the county attorney's office on that, so that we don't violate any provisions of the law. That's a question to the attorneys.
What I prefer, Mayor, is that if we table this at this point in time, and we have the public hearing this afternoon, we could find out whether or not the property has been designated as a public nuisance in any way, shape, or form, although I don't think that issue makes a difference in terms of the settlement at all. But if that's what the board wishes, we could do that.
Yeah, it's for discussion. All right, Commissioner Bonilla.
Yeah, I mean, I don't want to make the motion on your behalf, so yeah, and I'll second.
Okay, we still have other questions or comments. I don't know, Commissioner Uribe, if you're ready for a motion, but
No,
I see.
have one comment.
Okay,
Yes,
let's go to the comments, and then I'll go to Commissioner
Lee,
Wilson.
Please don't take this as in any ways disrespectful at all. I respect you as an attorney, all of you all, but I respectfully disagree. When people get pulled over and there's drugs in the car and it wasn't theirs, they're responsible. If crime happens in your home, they're responsible. This owner must have been living under the rock, because this is not the first time there's been criminal activity, and I would love to know if there's a nuisance. Commissioner Scott just even said he knows the man who was shot there. This is not a beautiful, bloomy park that just had one bad thing happen, and this is why we're here today. And I also want to urge my my colleagues. We fight for puppies, rabbits, golf courses, rural areas, split oak, rental ordinance. How about we take a risk to win? We win and do the right thing here for this community. I know you guys, you're lawyers, you got to tell us all the bad, but what about the good? I would love to have law enforcement be in front of us and tell us how much of a problem this location is. And how do we sit here and say, oh, well, we're just going to take it, financially, all these things that we have put you guys in litigation for, and we're not going to fight for this community and fight for the right thing. With that being said, I file a motion that we say no, and we do encourage our legal team to fight on this and try to not just say, you get to come and make a deal with us and we're going to let you come back. So I do file a motion that we vote no, and we send our legal team to go fight this and take the risk of winning and actually setting a precedent. You can't do this in Orange County. We're not going to take it.
Okay.
Could I briefly, I'm sorry. I thought it might be helpful to respond to just a couple of the points, but I'm sorry to interrupt.
Go ahead and respond, and then I have some comments.
Yeah, I'm sorry, Mayor, I didn't mean to interrupt. Okay. No, and Commissioner, I'm not at all personally offended by any of it, and I am well aware of the location and the activity, and like I said,
the owner knowing.
Yeah, and there's a prior federal iteration of this lawsuit. I've been involved for a long time on it. I've had many conversations with the attorney that is the general counsel for MBI, so I'm aware of it, and I'm not defending the owner. I would just simply say, to your analogy, respectfully, about the owner of the vehicle, that person would be charged criminally. MBI made it, and the state attorney's office made a decision not to charge the owner. I'm aware that a person and multiple people have been injured there. I know that the person was shot. That's the case that I read to you. There may have been more than one where the appellate court said, as a matter of law, the owner was not legally, civilly responsible. So again, I'm not advocating for the owner of being in any way, shape, or form. I'm advocating for the county, and I think in this particular case, even the wrongdoer had a right to challenge the revocation and any effect it would have on their license. The property owner, as our code stands now, did not have a right to challenge the revocation, and we fought this in federal court and got it kicked out. But the federal court's very limited, so we're willing to fight whatever the board decides. Our recommendation has nothing to do with a willingness or lack of willingness to fight. It's a recommendation based on what we strongly believe is the best interest of the
And thank
county.
you for believing that and protecting us as a county. My job is to look out for the people. and for our community. So my desire is a little bit different. And I understand, maybe I'd be willing to amend my motion to table it so that we can garner more information, but.
An executive session, too.
So let me just speak first. I have some concern here, and I'm probably the only person up here that has actually gone out and had to enforce the laws of our county, our state, and our nation. I do remind you that I've been a street cop. I did work cases here. I've been the chief of police in Orlando. I certainly have been the sheriff in Orange County. And I spent a full career, almost 38 years, fighting against the type of lawlessness, violent crime, seedy kinds of criminal activity and behavior within this county. I certainly have fought to preserve a high community standard and quality of life in this community. This is my home. I have not wanted Orange County to be the Las Vegas, if you will, of Central Florida, where there's the legalization of prostitution. And I believe that when you have adult entertainment, there's a fine line there with the legalization of prostitution. I would fight against that. I am concerned about the activities that have occurred at this property. Have been concerned about it over the years, but not, in all fairness, not just this property, but properties that engage and allow this type of behavior to occur on its premises. And it's disturbing. But yet, I also swore to an oath to uphold the Constitution and government of our great nation, our state, and even this county. And you can't argue. We happen to be legislators, and our predecessors wrote some ordinances that were codified. And if through the experience of having things happen, sometimes you find the imperfections, if you will, in the very laws that we write, and then the courts make appropriate decisions or decisions that we may not all agree with. It is troubling to me when I hear the county attorney's office say that we have a constitutional issue. That's no light issue for us to have to wrestle with. That's a major issue that we're talking about here. And there are consequences of failure in court. So I think that when we make decisions on behalf of our residents about engaging in fighting a lawsuit, we should be doing it from the lens of, can we win? Okay, we should not be just fighting just to be fighting to lose. It is significant that these attorneys are saying to us that we have a problem constitutionally. And all of you, if you remember the oath that you swore to uphold that oath. I've taken that oath, different versions, 7 different times in my career. I think it is significant what they are saying to us at this point. And so I don't want us to get lost on the fact. And to me, it's significant. The financial risk is one thing. The attorney's fees, that's another thing. But this issue about whether Chapter 3 of our code could be invalidated and perhaps open up a litany of other concerns. Sometimes you can cut your nose off to spite your face. I don't want to lose all of the provisions and the protections that we have to stop the proliferation of these types of establishments from being able to operate anywhere within our county. Right now, there's some significant hurdles and there's some restrictions. I'm concerned about the potential risk to opening that up to where we have the potential proliferation of these type of establishments throughout the entire county. That is significant. You have to adequately weigh the risk of when you fight. And they're telling us that there's a risk here that we can open up the entire chapter. To the extent that we can control it, as a law enforcement officer, having worked with MBI, having been on the board of directors there, I know what I know about the work that they do and trying to fight to maintain our community standards. That's a high bar that we have to face. That's a high bar that we have this responsibility as this Board of County Commission to help and to preserve. So I'm concerned about it. I do believe that given what the county attorney has said, given my history of being sued, being in court, fighting for the men and women who have sworn to all of those who go out and enforce the laws that we make, I do believe that we are supporting them in this effort. I do believe that we're supporting the taxpayers of Orange County and the protections that they have. So I think this is a slippery slope here. And so I believe that there's sufficient information by which to make a decision based upon what is before us today. Be careful. Be careful about simply wanting to make a statement for whatever reasons that can cause us unintended consequences. And there are unintended consequences here, I think. So those are my comments at this point. Commissioner Wilson.
I'm sorry, I have a question because I'm back to this provision of the settlement, number 3. Plaintiff fully releases the county and tax collector from all claims, and plaintiff will file voluntary dismissal with prejudice, contingent on the board approving the settlement and AEC amendments and the tax collector issuing the new adult entertainment license. How are we able to, in a county settlement, add a different constitutional officer's permitting process?
The tax collector is a party to this lawsuit, Commissioner Wilson. The main attacks are really against Orange County and the code. But the tax collector has counsel that we've talked to repeatedly. They are named in the lawsuit.
Okay,
Thank you.
all right. So that because this, like I said, this is the piece that for me feels the most troublesome.
Yes.
Is that this whole thing is contingent. Obviously, the approval here of the settlement, I know it's been probably a very long and strenuous process to get to this. But the idea of some guarantee of an outcome that really shouldn't be guaranteed until the end of the outcome, right? A permitting process is a permitting process for a reason. This is the piece of this that I have the biggest problem with, speaking for myself.
And I don't know if there's anything can be done to deal with that issue that Commissioner Wilson is bringing up pursuant to this action that is before us at this point.
No, I mean, the only thing I would add, again, the tax collector's a party. They're a party to the language. The settlement agreement makes clear to the plaintiff that, one, there's no guarantee of approval of the settlement by the board, and that there's no guarantee of issuance of a license by the tax collector. But yes, you're right, Commissioner Wilson, that's part of the settlement. If they sign, if the board approves it, then the next step is for them to apply for the license. If that's issued, then it's done and it gets dismissed. If there's some hiccup and it's not approved, it may be they have to get a different...
So this is all set aside?
They might have to get a different tenant and try again. or.
But what
we
the
would-
settlement is set aside if that happens?
Yes.
Okay.
Yes, it could be. Just like if the board doesn't approve it, if the tax collector doesn't issue, it would be set aside.
Thank you.
Yes, ma'am.
Okay. Commissioner Scott?
We woke up this morning not knowing that we would wake up, and I'm always cognizant of being aware of people's time. On any given issue, at some point, we may have 1, 2, or several meetings with the county staff. I would have asked that, my fellow commissioners had posed some of these questions to the county attorney prior to this meeting and given them an opportunity to respond. The nuisance abatement deputy is Deputy Irwin. I won't say her first name. I know her well. There isn't a host of complaints, and no more than any other establishment, La Palace, all these other places. But, I just don't think this is the best use of our time. I don't think we should not accept the settlement. I'm open to having a conversation, preferably this day, but we trust each other to represent our districts individually, but also make decisions collectively. And I get that you might not agree, you may shake your head, but it is my district. And so just trust that I've done the due diligence as the District 6 Commissioner, as you would with an issue in your district, and trust the judgment of the county staff. I trust our county attorneys. I think they've done a great job. They have a whole lot of things on their plate. And so, I think they've done proper due diligence, and they wouldn't bring us, less than adequate counsel. We've had some great points that are made today, but I don't see any reason to belabor this any moment. But I just want to put those thoughts on record that, I very much like to move forward from this. Thank you, Mayor.
Commissioner Bonilla?
Yeah, regarding our time, that's what we signed up for as elected officials. We give a lot of time.
The people's time.
People's time? Well, our time is to make the best decisions as possible, and we invest that time. But I'm not saying that we should vote no on this. I know Commissioner Uribe has amended her motion, and we have to take into consideration, this is $1,650,000 settlement. I don't think that we should go ahead and make a decision without having our executive session that we should be having on these types of issues. And I think probably moving forward, if the district commissioner is, unsure about a settlement, that we should have those executive sessions to discuss these legal matters.
But I'm not unsure.
But you're not the only district commissioner.
Where is this located, Lee?
It's in District 6.
Say it again. Where's it located?
It's in District 6.
My district, correct?
All right. Commissioner Bonilla, anything?
Yeah, I'm just going to go ahead and second to table this so that we could get more information on this, because this is a huge impact on our district without having the proper information to make a decision.
Okay. Just a point of clarification. In terms of Commissioner Uribe's motion, I'm not sure that.
I amended it.
What is the motion that you are making at this point?
So
Commissioner Uribe?
I did agree. So I just want to make it clear, I did have a meeting with the attorneys, and I made it very clear, Mr. Newton. Didn't I tell you when we met that I was going to pull this because I did not feel that this is something.
You mentioned that you were going to comment on it.
Yeah. Well, pulling comment. That's what I'm doing. That's okay.
That's fine.
So there was never a deception. I didn't throw you out of left field.
Everything that you have mentioned today, we discussed with you, just like we discussed with every other commissioner. And
I just didn't agree.
Excuse me?
And I just didn't agree. That's why.
You said you would comment on it.
Yeah. And I did read the letter from the lawyer, and
okay.
I want to go ahead and amend my motion to table it to see if staff can meet with us any further to pursue us fighting this, like we've fought many, many, many things in the past of much less worth for our community.
Okay. If that is the motion, Commissioner Bonilla, are you seconding that motion?
Yes, I second.
And that's table until what period of time?
Well, we wanted a table for strategy with our legal counsel on what are the ways we could pursue fighting back.
I think we need to we couldn't table that indefinitely.
No.
So you need to put a time period on it.
I would ask the attorneys, well, that's a great question, Attorney.
I'm like, okay, I don't think, this isn't a land use case, guys, so it's not like there's a date known. If this settlement falls through, the plaintiff has the opportunity to move on to litigation, right? Is that?
They have the right to move forward with the litigation.
Yeah, so that isn't, this isn't like.
Lee,
this
We've
isn't
asked that question already and haven't had an answer.
There was something that
That's-
I don't recall off the top of my head, it was something that we postponed for a period of time. There was a hearing, was it a hearing?
There was, with the litigation we're talking about is stayed temporarily since the end of January for this process to take place. There was no exact timetable put on it, at least in the court documents. Plaintiff certainly has the concern of desiring to move forward and get an answer, yes.
Okay. I still think that there should be a time period.
Yeah, can we have a
cannot
date?
just table this indefinitely.
We're looking for the attorneys to recommend a date.
Well, I've given my recommendation in terms of moving forward on the issue today.
We're
And so
asking
from
for
a
a date.
time period standpoint, that's up to you all. If you want it to be a month, 2 months, 3 months, whatever.
Okay.
How about the second meeting in May? No one else is choosing a date.
Yeah, I mean,
The 21st, May 21st.
I thought you were talking about executive session, not separate.
Well, we
from-
could have the executive session that day, and then we could vote on it that afternoon.
Okay.
I agree.
Okay. If the motion is to table until the afternoon of May
21st.
21st, and it is understood with the seconder that that's the motion, then I'll call the question. All in favor of tabling until May 21st, say aye.
Aye.
Opposed, no.
No.
No. All right, so I'm not sure. We'll do a voice vote. Commissioner Wilson?
I'm a no.
I didn't hear what
No.
you, no,
No.
no.
Yes.
Commissioner?
Yes.
No.
And I vote no. So that motion fails, and it fails 5-2. Okay, so 4-3. 4-3.
Motion to approve the settlement.
Okay, second the motion. All right, we have a motion and a second to approve the settlement that has been offered today. Commissioner Wilson?
No.
Commissioner Moore? Yes. Commissioner Uribe?
No.
Commissioner Gomez-Cadero?
No.
Commissioner Bonilla?
No.
Commissioner Scott?
No.
Okay. No on the settlement. Okay. I vote yes. Okay, motion fails. Okay, so the motion does fail on settling the case today as presented. So is there another motion?
Could I make a motion to, I guess amend the settlement with that provision that I think is troublesome on the contingency of them going forward with the permitting and achieving that? And I don't know if this is a way to, I don't know how to give you the empowerment to go do that, knowing that this has been an ongoing negotiation, and that was probably a big sticking point already. And I know we had these conversations
Well, already
before
they're
this.
going to have to go back and
But I
negotiate.
don't think we need a strategy session behind closed doors. I think it's all laid out. We know what they're asking for. I feel like I know what our concerns are with the inability to continue to have some oversight in that permitting process. So I don't know if that looks.
I just think this discussion should have been.
Okay, all right. To the county attorney, I'm
So
not sure you
Commissioner
understand
Wilson,
the
you would
question.
just want there to be a statement as part of the settlement agreement that there is no guarantee that the tax collector
Yes.
would approve the application?
That's right.
Okay.
But isn't the state, doesn't the tax collector actually issue it based on our allowance of the property usage? So regardless if you put it in there or not, if we allow that non-conforming use, he has to issue it.
No,
there's
not
a
at all.
process.
What
Not at
legally
all.
gives
It
them the
goes
right to
through a
deny it?
It goes through a process.
Right, which-
And so if,
I'd like more
depends upon
clarity
who
on
the
it.
applicant is. And that applicant has to
that's
meet
just
the
their background
criteria
checks.
of the statute.
Well, that,
So
and-
that language is there because ultimately, whether you like it or not, ultimately, they're going to find a tenant to go in there. and that's going to meet the requirements of the ordinance. So that's to me is a foregone conclusion. But if you want that language in there to say that it's not a guarantee,
Right, the
then
contingent
that's fine.
language in here, where it says contingent on,
Right.
and then there's the next sentence, which I feel like is problematic. If that can be clarified in that those processes continue to be the permitting processes that are in place based on our.
Can we learn more before?
Well, I'm sorry to interrupt. Yeah, when the tax collector gets an application, they send it out to various entities. I may not remember all of them, but one of them comes to our zoning department who looks on the distance zones. One of them goes to Orange County's fire department who makes sure the structure is safe and compliant with the fire code. Goes to MBI, who does appropriate background checks with the individuals who are part of the licensee or proposed licensee. I would just indicate also there is some discussion in paragraph 4 of the proposed settlement agreement that does indicate that the application will be processed by the tax collector pursuant to Chapter 3 of the Orange County Code and pursuant to the tax collector's standard policies and procedures, will not be withheld, conditioned, or delayed. It then indicates that they understand the license, if issued, would not be issued before April 13th. And then the last sentence says this agreement does not constitute a guarantee of approval of the adult entertainment license application. So that's in there, but
All right.
I hope that clarifies.
So the language is there, but I think, Commissioner Wilson, correct me if I'm wrong, it makes it seem as you read, if you don't read down, that the approval is guaranteed, right? Saying issuance of the license.
It literally says contingent upon, and then it says in the tax collector issuing a new adult entertainment license, which sounds to me like we're all hanging in the balance of this contingent.
And that's about, and I'm sorry, I don't mean to.
No, I want you to
address both what you and Commissioner Scott are saying. There's no guarantee, but just like we as Orange County, one of the parties, needed to convey to them that this is contingent on board approval, the plaintiff has the contingency that we get to apply, and if the tax collector does not issue it to our new applicant or the replacement applicant, then there's no settlement. And by the way, I didn't talk about the time period. The time period's pretty quick. When the tax collector gets an application, it's normally 30 days within which they get all the information back from the entities and then reply to the applicant.
But don't you think that that's a large risk then? So let's kind of zoom back just a second. And knowing that that's the case, and let's say there is, some problematic applicant for the permit, now all this work is still in peril, right? Because if they don't get what they want, then we're right back here, based on this clause.
I'm sorry, I didn't mean to.
No, you're good.
Yes, you're correct. If they apply with a new applicant and the tax collector does not issue the license due to their whatever reason, their policies and procedures.
Legitimate reason.
Then yes, the litigation, that is their right, is to move forward with the litigation. Now, they could also try a new applicant. They certainly know that there's no guarantee, but they know what the process is.
But you don't worry that this is foundational for them to continue to linger with this lawsuit over our heads forever and ever. Amen.
I'm sorry.
No,
Again, I spoke over you. I thought you were
very wordy.
Certainly, that's not their desire. Their desire was for this to move forward much more quickly. Their desire was not have to sit out the 12 months and to get back to having someone there doing business and paying them rent. So it's not there as a desire. It's just, hey, we're giving up something, you're giving up something, we understand we need that. We need the contingency of making sure, not just that you say you will process an application, tax collector, through your normal policies and procedures, but
It can't be performative. We actually have to apply the permit. I understand what you're saying.
Yes.
So you could,
I hope that
you could
answers it.
reconsider
Yeah, it did.
You could reconsider your motion that you just made if you'd like to. You don't need any new information. You can do a motion to consider at the same board meeting and then bring back the question of whether or not to accept the settlement agreement.
Okay.
Okay.
Motion to reconsider?
Commissioner Wilson, you understood?
No,
what he
I
was
don't.
just
I'm so
saying.
sorry. My brain just splintered
You
into
had
1,000
You had
pieces.
voted no, Commissioner
That's
Wilson,
right.
on a settlement agreement, primarily, at least I understood it to be
From this
primarily
piece.
because of that provision.
That's correct.
If you are now comfortable with the provisions of that settlement agreement that you had pointed to as perhaps the reason for your no vote,
I'm
then
not
you
comfortable with
could reconsider
I
if
got
you
you.
wanted
No,
to
I'm
reconsider.
not.
your vote.
Okay, no, thank you.
Mayor, am I able to, well, I guess question of process, CPU or Jeff. We voted no to accept the settlement. Is it possible for us to get clarification on the language or revision in the language and you bring it back at the next board meeting? Is that timeline feasible?
It's a no. It's a denial.
Or is it dead in the water?
That's feasible. You may be able to table it this morning, and we'll have a conversation with council and see whether or not they would be willing to
Well,
revise that
because
language.
at this point,
And we're going to because you have a public hearing scheduled this afternoon, so you're going to have to at least open and close the public hearing, or just because of the fact that it's been advertised. So we could consider that different language at this afternoon if it could be done. But at this point, we've been at it for quite some time. If you just want to wait until the May 21st and have a closed session, I don't know what the point of the closed session is, but we can do that too.
all right. Not sure where we are.
It doesn't hang on me. I'm just saying that's where
Do we have a motion on the floor?
It's been denied. We're trying to move
Com-
on.
Oh, I went to
What
the
was
bathroom,
the
so I just didn't
what was
know
the vote
what I
on
missed.
the failure of accepting the 5-2? All right. So with that, we'll move forward. Okay. All right. So we'll move to the next item on the agenda at this time, which is the discussion agenda. Thank you to the county attorneys. We're going to move to item A1. We're going to have Ms. Tracy Atanasio to come forward regarding the procurement items.
Good morning, almost good afternoon, Mayor and Commissioners. Discussion item A1 begins on page 551 of your agenda. The Procurement Committee has evaluated proposals for interior design services at Orange County Convention Center. I am requesting board selection of one firm and 2 ranked alternates. Commissioner Moore was assigned to the Procurement Committee.
All right. Commissioner Moore, would you like to offer a potential motion?
I would. I move for the selection of TJNG Partners, Inc. at 408.88 points, with Proven Management LLC at 332 points, and Designers West Interiors, Inc. at 314.69 points as the ranked alternate.
Second, Uribe.
All right. We have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. The motion passes, and it is unanimous. All right, we'll move to the next item, and this is item B1. We're going to ask Ms. Beth Jackson to come forward from Environmental Protection to present the Green Place program. She's providing the annual update, and no specific action is being requested on this item today, just simply informational. All right.
Good morning again, Mayor and Commissioners. Today I'm going to be providing an annual report on our progress on the preservation of our environmentally sensitive lands, as well as providing a brief overview of some of the other things we do within the Green Place program. So, brief overview of the program, overview of our advisory board, talk about the environmentally sensitive land acquisition process, then a year in review, and summarize the presentation. So the vision of the Green Place program is to preserve environmentally sensitive lands that foster a community that is ecologically, economically, and socially resilient. There are many public benefits to preserving our environmentally sensitive lands, but here are a few of them. They protect our water, our wildlife habitats. They protect our surface and groundwater resources. They do foster a resilient community. That was one of the reasons why we were selected for that Diamond Award. Foster sustainable growth, foster economic diversity, as well as a healthy community. The program was initiated in the 1990s. To date, in partnership or on our own, we've managed to preserve 23,903 acres. 18,342 of those acres are open to the public for nature-based recreation, and that's a combination of our partners operating those properties as well as Orange County. Currently, staff, the Green Place program is managing 5,912 acres. That will grow as we preserve more lands. Support for the preservation of preserving our environmentally sensitive lands was through the Mayor's Transition Team Report, as well as our Sustainable Operation and Resilience Action Plan. And the goal was to double by 2030 our current holdings. So this is a map of where all the Green Place properties are in conjunction with other properties within Orange County and outside of our county boundaries that have been preserved. This is an overview of actions that were previously taken, our presentations in January of 2021. We provided a work session to the board, and the board approved a budget amendment of a payback for a bond. Later on that year, we brought back the proposed resolution for the reestablishment of the Green Place Advisory Board, as well as updating the administrative regulation to add additional criteria. In September, which we are very grateful for, the board had the foresight to allocate $100 million for the preservation of environmentally sensitive lands. Later that month, we brought back that resolution reestablishing the Green Place Advisory Board, and then in November, we updated the administrative regulations. So now on to the Advisory Board. Their first meeting was in February of 2023. There's 7 members. They meet 6 times a year. They have 2-year staggered terms. 4 of those terms will end at the end of this year, and the other 3 will end at the end of 2025. And Agenda Development will work with either refilling those positions or re-engaging the current members to see if they want to stay on the board. Their duties are evaluating and prioritizing new parcels. By that, what we mean by that is the previous boards laid out areas where we should look to, but they did not finish that work, so we're looking to the current board to help us with that work. Recommending names for the board approval, evaluating Green Place uses and policies, reviewing potential amenities, as well as providing an opportunity for public engagement to the process. And there's a picture of the advisory board. 1 member is missing. So they hit the ground running, and one of the things they did was they established their own mission plan, which is to ensure the strategic acquisition of ecologically diverse lands to enhance the quality of life for residents and visitors of Central Florida. And then we took several meetings to do some goal development with them. And then the goal that they decided to focus on was to look at how to provide a dedicated funding source for preservation of environmentally sensitive lands and other revenue-generating streams. They approved a branding guide that included a new Green Place logo and a web page concept. The Green Place program has been working on a master plan with a local consultant for over 3 years. So we brought that to the advisory board for their input and approval. They reviewed and approved the evaluation process companion guide. So what the companion guide is it's a list of tools that we use when we go to evaluate these parcels that we wish to potentially acquire through the Green Place program with that $100 million. They reviewed the selection process for parcels for potential acquisition through the Green Place program, which was one of their duties that I listed earlier. And what that was is giving staff guidance and direction and support on a strategy that we laid out to them on how we would look for potential future acquisitions in those areas that had previously not been identified, or if they're aware of parcels within the previously identified areas, to bring that to our attention. And they recommended the naming of Pine Plantation to Green Eyes Wildlife Preserve. And the board, yes. And there's a photo of Green Eyes. It's sometimes referred as the chocolate daisy because if you smell it, it smells like chocolate, but you can't eat it. So now on to the environmentally sensitive lands acquisition process. So as previously stated, we do use the criteria as established in Administrative Regulation 11.07.01, and we continue to enhance the standardized evaluation and scoring methodology. And by what I mean by that is we meet 2 to 3 times a month, depending on the month, to evaluate parcels for potential acquisition. And, you know, we have robust discussions sometimes on the criteria to make sure that we're understanding it and we're consistently using the same thought patterns and decision-making patterns to come to a score. And then we continue to enhance the scoring companion guide for consistency. So we're always looking for new tools to use to evaluate these parcels. And then we streamlined the parcel nomination process. And by what I mean by that, we do have an application so that if someone is a willing seller, they can nominate their parcel, and it just takes out one step of the process. And then the acquisition process, we continue to work with our partners in real estate management to improve an efficient workflow process. And they acquire these parcels in accordance with Administrative Regulation 6.05.02. And so we do look for partnerships because we want to leverage the funds that the board has provided. So Representative Soto came to the board either in 2023 or late 2022, and he said he was going to earmark $500,000 in the federal budget for the preservation of environmentally sensitive lands. So in March 2024, the Congress approved that budget, which included that money, and we will be working with his office to seek reimbursement for some of the parcels that we've preserved through the program. We're going to continue to look for those type of partnerships, both state and local. Some of the state ones we're doing we're partnering with South Florida Water Management District to acquire parcels in the Shingle Creek area. And we did partner with Public Works to acquire parcels in District 1. Both of us were interested. I know this is a touch point. This is a sticky point for Commissioner Wilson. But both of us were interested in these 2 parcels. So we purchased the majority of it, and Public Works purchased a small portions of these 2 properties, one we haven't closed on, in order to provide right-of-way for the widening of Reams Road. And one of them will also provide an enhanced wildlife crossing. No stormwater ponds, though. I found that out. So this is a map of the properties that we've been able to preserve so far that occur within eastern Orange County. And you can start to see a pattern here of where we are acquiring parcels. We're trying to link up existing publicly and privately owned conservation lands, as well as some of them do provide a buffer to parcels that we have already purchased. And this is what we've been able to preserve in western Orange County so far. So the properties within the northwest portion of the county, that one above the orange line is actually in Orange County. It's just an artifact of GIS, you know. Okay. We also added lands to our Sandhill Preserve. And then there's some in the southwest portion. We preserved that one parcel along Reams Road, as well as we're preserved 4 parcels so far within what we call the Black Tilden Lake area. And it's a major wetland system, so that provides a lot of water resource protection, flood protection. And so now I'm going to go over some of the specifics. And this is a cumulative graphic. So to date, we've preserved 23 parcels. The board has approved 37 contracts. We've appraised 92 parcels. We've determined 164 willing sellers. And EPD has evaluated 1,378 parcels. And that's between July 2021 and to present date. And we've preserved 556.37 acres. So this graphic is what we've done for this reporting period. So you can see where we have really started to move the needle. I know it can be frustrating that it seems like it takes a long time, but we're just, the ball is rolling now. So we preserved 16 parcels this year. The board approved 22 contracts. We appraised 46 parcels, and we determined 74 willing sellers, and we evaluated 940 parcels. And so these next 3 graphs or slides will narrow down some things for the board. We've preserved 556.37 acres. The orange, 1,198.99. Those are some of the those are the contracts the board has approved that are in the due diligence phase. So when you approve a purchase contract, we then go to a due diligence phase, and we do the boundary survey, the phase 1s, title searches, title insurance. And then once we determine that we can close on those properties, they will then add to that green. The 2.3 acre yellow is a contract that we had hoped to bring to the board prior to this presentation or today, but it's been delayed a little. So, and it's assigned what we call a letter of intent, but they've also signed a purchase contract. We just need to bring it to the board for your approval. So shortly, you know how it works out. We're going to be closing on close to almost 1,000 acres right after this presentation. So that'll be nice. This one is land cost per acre, and it's just $29,751.05 for what we already own per acre cost. What's pending, that is $21,246 per acre. The yellow is that small property. It's $110,434, but it's really based a lot on the location of these parcels. This one is in a more urbanized area, but it will help to preserve the wetlands on the northern shore of Johns Lake, where we already own Johns Lake Conservation Area. And then here's the money. This is what everybody wants to know, what we've spent, what remains. So to date, we've spent $16.5 million. Those pending contracts will once they close, will be another $25.5 million. I'm rounding it up. And then there are support costs. So in order to bring these items to you all, we have to appraise them. And then we have to do those boundary surveys, the phase ones, the title insurance, and title searches to make sure there aren't any liens on the properties. So what remains is $56.6 million approximately, and that we have the opportunity to preserve more lands. And we do have several opportunities in the pipeline, and we hope to bring those to the board in the future and spend more of that money. And so this is just a tabular form of some of the information I've provided. 37 contracts that have been approved by the board, preserved 23 parcels, total acreage 556, total funding committed 42.2, acquisition cost per acre is 23,206, and we've been able to preserve lands within District 1, 2, and 5. So this portion of the presentation, I'm just going to highlight a property that we have been able to preserve, and it's in the northeast Orange County. It's the Narrett property, St. Johns River Drainage Basin. It's an expansion of an existing ecological corridor, so it's directly across from Charles H. Bronson State Forest. But what you don't see is what's beyond that and north and south of that. So there's over a 300,000 acre corridor there. It's 212.22 acres. This has been the largest acquisition to date in the program, and we purchased that for $5,550. We will be closing on another property just south and west of there. That will be a 738 acre parcel. And so now to southwest Orange County, we're going to highlight the Bronson Fairchild property. It's in the Cypress Creek Drainage Basin. It's 20.53 acres. It helps protect our water resources and wildlife corridors. So you can see where it's located with some of the areas that have been preserved by some of the developments within the area. And then we did partner with Public Works. They purchased their own little portion of it for right-of-way purposes. And the purchase price was $2.7 million, but it's where it's located. You know, they always say location counts, or, you know, pick your location well. But we're happy that we're going to be adding to that wildlife corridor that's there. And so now, year in the review, our Green Place program does a lot more than just preserve these lands. We do a lot of other activities, and we wanted to highlight those briefly for you. So again, we've evaluated 940 parcels. For this reporting period only, we've preserved 365.1 acres. We do capital improvement projects, so it's very important for us not only to preserve these, and some of them are going to be straight preservation and will never be open to the public because of their location. But we feel it's important to open them up for nature-based recreation because people do not protect what they don't love. And so we do a process. We first assess these potential amenities, then they go to design, and then construction. And we've completed 2 capital improvement projects this year. And one of them is highlighted in the photo. It's a Hidden Pond Observation Platform. And even though the parcel is a pretty small parcel, we have gotten so much positive feedback from the users of the property that they really enjoy that amenity and enjoy going out and walking in the evenings on the property. And so land management, just like people, even the land needs a little TLC sometimes, so that's what we do with our land management activities. We conduct controlled burning. We do invasive species surveying and control both. We use an integrated pest management process for that. We do forestry management. If a property needs some restoration or enhancement, we will work towards doing that as well. And then nature-based recreation. We do have 14 open nature-based recreation properties. Some of them are operated by our partners, but 10 of them are operated by Orange County. We maintain 30 miles of trail. We provided 3 guided hikes last year and 3 outreach events. So the photo is of one of our outreach events at the Dell property, it's now part of Savage Christmas Creek Preserve. And then we constructed a bird blind on Johns Lake Conservation Area, and we're going to be cutting the ribbon on that this Thursday at our Earth Day event. So in summary, since 2021, the county's been making excellent progress in judiciously expending the $100 million approved by the board. We've preserved 556 acres of environmentally sensitive lands. The Green Place Advisory Board has achieved many significant accomplishments, and we look forward to working with them in the future. We received the Executive Award of Regional Significance from the East Central Florida Regional Planning Council. And we want to continue to open parcels to the public for nature-based recreation. And that's the conclusion of my presentation. Thank you for your time.
All right. Great job. Commissioner Wilson.
Sorry, that was so fast. I so appreciate it, and I know you all deal with me a lot, so thank you. I have to give Minnie a shout out, because I know that the process, I think from the public perspective, they don't realize the intensity of the evaluation that the advisory board goes through, and then once it even is identified, then the long work takes place, right? And for anybody that's purchased a piece of property just for their own personal use, you know how long that takes. You can imagine adding the multi-layered types of protections and evaluation that we have to do as a county. So I thank you for being available also for my staff when they need to have some information, and for my residents even. We've had some small meetings with residents that were curious about what it meant when things went into the Green Place program. Quick question about, it's very exciting to see that we were able to form some partnerships at the federal level. What happens then with that revenue that was earmarked, that if there's some coming in, does it go back into the bucket for Green Place and essentially become additional revenue, or does it offset previously expended revenues in that $100 million?
Our goal would be, but we would need to seek the advice of our financial partners in the county, but we would like to see that reimbursement money, that $500,000, go back into the fund that we use to preserve environmentally sensitive lands.
I would support that, and in fact would hope that there was a way for us to be able to structure that, so any future potential revenue sources that I know the board is seeking potential revenue sources that can be sustained over time, that those then also have an area that they can get into. I believe for a very long time we've had Green Place in the books, but there wasn't that dedicated revenue source because there was, there's endless needs and sometimes limited revenues, and so those competing needs win the day. And having something very dedicated in a trust or in some other protected mechanism, I think would be an incredible goal for this board to achieve in the coming days, weeks, and months, knowing it's been a huge accomplishment to have seen this kind of addition to our Green Place properties over these last couple of years.
In addition to the fund that we use to preserve the environmentally sensitive lands, we have a conservation trust fund, which we would, if we're unable to put those dollars back into that, we would ask that they go there. And we use a lot of those funds to manage the lands. But there's also the opportunity that fund also has the opportunity to preserve lands. It's just the balance is not there, and we try to protect it to make sure that we're continuing to enhance and improve the acreage that we've been able to preserve.
Absolutely, it's all important. And actually, that brings me to another question, a follow-up question about the types of lands. I know that I think there's a lot of attention given to our wetter lands and the mitigation that we're able to get and flood mitigation and those ecosystems. But we also know the value of the uplands and scrub habitat. And I was wondering how, the approach has been to getting that balance in making sure that we have multiple habitats included in the Green Place program.
So that is one of the criteria, ecosystem diversity, and a lot of people just surmise that we are just interested in protecting wetlands, but we try to protect both, and we have been very successful in protecting both upland as well as wetland type habitats because they are interdependent on each other, especially for wildlife. So the Narrett property that I highlighted, it does have scrub habitat on it. Those properties up in the northwest portion of the county, that was the largest acquisition of scrub habitat that we've made to date in the Green Place program. And then the 738-acre parcel that we hope to close on also contains scrub habitat and scrubby flatwoods.
That's great. That's great news. I think the continued sort of education around that too. Yes. I know that when we talked about our tree ordinance, there was a lot of discussion about how do we protect that scrub habitat, knowing that the criteria for sometimes our protected hammocks are not necessarily, it's based on this, this circumference, which doesn't really indicate sometimes the importance of the biodiversity. So I appreciate all the education efforts that you all have engaged in the last couple of years, and whatever I can do to support from our angle. I know that our residents continue to be completely and 100% supportive of these efforts. And I mean, it's the one thing that if I have everybody in the room screaming about everything else, if we can bring up some of the efforts that have been made by EPD and conservation and environmental protection, everybody's on the same page. So I really appreciate those, and thank you for the update.
Thank you.
All right, just to the board, we do have 3 items that we're trying to get to this morning. We do want to hear Commissioner Bonilla's special report. So let's try to get through the balance of this as quickly as we can. Commissioner Bonilla.
Yeah, I'll definitely make it quick. Thank you. Thank you for all the efforts. I just want to make one comment, and that is that I'm so glad this is coming up on the same time they're asking for the Lake Pickett, some of these parcels to be taken out, because that Lake Pickett North development, if it had gone through, would have had or needed a road to go through one of our Green Place properties that we had just recently purchased. So we definitely need to also have in place some ways to protect our Green Place properties from, having roads go through it or used for other purposes than conservation, which we don't have any policies at the county right now protecting our Green Place properties from other uses besides conservation. So that's just my comment there. Thank you.
All right.
Thank you for your time, Mayor.
That's the final comment. Thank you this morning. Thank you to the team. We're going to try to move quickly through these next items so that we can get it in, hopefully, before we take a brief lunch break. And so with that, the next item I'm going to call on Ms. Whitney Evers to come forward. Roseanne Harrington was going to be presenting this item, but she's a little under the weather this morning, so she's not able to be here. So Ms. Evers is going to do that. And so with that, you're recognized.
Thank you, Mayor. Good afternoon, Mayor and Commissioners, Comptroller Diamond, Mr. Brooks. I am here to give you the update on the Pulse Museum. I'm going to talk briefly about the purpose, go through a little bit of background, talk about our due diligence findings, the action items that we went through, next steps, and then finally the requested action. Obviously, today we're here to give you an update on this, let you know where we are with the agreement and the next steps as it relates to the Pulse Museum property. Quick background to reframe this. As you'll recall, the Tourist Development Council approved the funding for the Pulse Museum in September of 2018. Shortly thereafter, in October of 2018, this board approved the agreement to provide up to $10 million from excess tourist development tax revenues for land acquisition and design fees to the One Pulse Foundation. As a result, in September of 2019, they purchased a 1.7-acre parcel of property located at 438 West Cayley Street for $3.5 million. Skipping ahead to October of last year, the foundation notified us that they were not going to be able to move forward with the museum, and at that point they had spent roughly $6.5 million of those TDT funds on land acquisition and design fees. This shows you the location of the property. It's in the corner of Cayley and Division, right there adjacent to I-4. In terms of our due diligence findings, again, on October 27th, when the foundation let us know they weren't able to move forward, they did request that the county would terminate the Pulse Museum TDT agreement and accept conveyance of that property. You'll recall that in November of last year, staff did provide you an update on where we were at that point, and we received direction from you to perform the requisite due diligence and to develop the termination agreement, memorializing the terms and timing of the conveyance of the property. So from December of last year through March of this year, several folks from the county have been performing that due diligence, including real estate management, capital projects, risk management, facilities, county attorney's office, OMB, as well as the comptroller's office. You'll recall that when I was here last November, I did discuss with you that the foundation, in addition to our TDT agreement, also entered into an agreement with the state of Florida on the cultural facilities grant for the Pulse National Memorial and Museum. That grant was for up to $500,000 to cover the costs associated with constructing the museum. They actually drew down just under $400,000 of that, about $394,000, $321,000. So as a result of that, the state of Florida recorded a restrictive covenant on the museum property. That restrictive covenant limited that property to being used for a cultural facility. Otherwise, the funds had to be repaid. Happy to report that the one good news item here is that we did manage to negotiate with the foundation. They did repay that grant money to the state, and the state has confirmed they received that and recorded a release of their restrictive covenant. So, silver lining there. Property taxes, you'll recall that last month we did come to you and ask for permission to pay the property taxes because, as we learned as part of our due diligence, the foundation had not paid the property taxes. They were just under $52,000 and they were due by April 1st. You approved payment of those on March 26th, and we did get them paid on the 29th, and thereby avoiding any interest and penalties on those property taxes. In terms of the action items, when we spoke to you last November, we did tell you we had a list of next steps that we needed to perform. So this gives you what we did with those next steps, starting with reviewing the foundation financial documents and board meeting minutes. Comptroller's office took the lead on this. We did negotiate with the foundation to get those financial documents. They refused to give us the board meeting minutes, however. On April 3rd, the Comptroller's office received a flash drive with those financial documents, including copies of bank statements with canceled checks for all the TDT funds received pursuant to their design cost requisitions, as well as a year-end statement of activities and financial position. I have not heard any issues with what was on the flash drive, but I'm sure the Comptroller can address that if you have any questions afterwards. In terms of the physical inspection of the property and due diligence there, real estate management, capital projects, risk management, and facilities did take the lead on that. We have done title review on the property, which came back clean. We've done an environmental assessment, which also came back clean. We've done 2 appraisals on the property, and the average of those comes out to just over $4 million. We also did an asbestos survey on the property. We did find a small amount of asbestos in the building. 6 of 52 samples contained asbestos. And as part of our due diligence, we did some building inspections between December and March of this year. However, we were only able to inspect the building itself. We were not able to get onto the roof because the structure itself is unsafe, and our staff did not feel it was safe to put anybody on the roof at that point. As far as the termination agreement, real estate management and myself have worked together on this. We did draft the agreement. We have a signed copy of that from the foundation at this point. In that agreement, the foundation represents and warrants that their interests in the property are free and clear of any and all encumbrances that weren't there when they purchased the property. They are required to deliver a deed to us within 10 days. We already have that. Prior to conveyance, they were required to deliver those financial documents and execute a release to the county's restrictive covenants. As I mentioned, we have those financial documents. We also have their signed release in hand as well. Termination agreement also requires that the county will record the deed and the release and pay any recording fees thereon. We also are required to provide a copy of both of those to the foundation, which we will do as soon as we receive approval today and we get those recorded. And then the TDT agreement itself will terminate upon the last of the deed, the county release, and the state's release being recorded. As I mentioned, the state has already recorded their release just a week or so ago. And again, we will record ours as soon as you approve this today. Special warranty deed conveys all of the foundation's interest in the Cayley Street property to the county, and of course, we would file a release of our county restrictive covenant so that that is no longer in the chain of title. In terms of the next steps, obviously approval and execution of the termination agreement, approval and execution and recording of the release, the county's release, as well as the special warranty deed. Following our recording of the deed, and we actually will take ownership of the property, staff will go back out and do a further inspection on the property, and we'll have to come back to you at some point in the future to recommend what we would recommend to you as far as disposition of the property, and then you'll have to determine what you want to do with the property at that point. Requested action, approval and execution of the termination agreement, approval, execution of, and direction to staff to record the release of restrictive covenant, and acceptance of and direction to staff to record the special warranty deed. And I'm available for questions. We've also got several members of staff here to answer questions for you.
All right, move the requested action. Second. Have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. The motion passes, and it is unanimous. Thank you, Ms. Evers.
Thank you.
We'll move now to the next item on our agenda, and this is item C2, and this is regarding the City of Orlando annexation ordinance, reference to Sunbridge. I'm going to, at this time, call on Mr. Andrew Mai, Assistant County Attorney, to frame this item. And with that, you're recognized.
Thank you, Mr. Mayor. My name is Andrew Miley. Like the mayor said, I am the Assistant County Attorney for Orange County. As you are aware, despite the county's opposition, the city has annexed approximately half of the Sunbridge area and 2 other properties as depicted in the packets, and I'll show you in a second. Yesterday, I attended the City Council meeting at the City of Orlando, and they unanimously approved the first reading of an ordinance which, if approved on second reading, would also annex the southern half. So the entire Southbridge area, or Sunbridge area, would be annexed into the city at the May hearing, where they will have the second reading of that ordinance. But before you today is a resolution which, if adopted, would institute the conflict resolution procedure under Chapter 164. And this is in regards to the county's opposition to the city's annexation of the Sunbridge property. This is for the first half of the annexation. This is what this would deal with. Should the city choose to adopt the second annexation ordinance on the second reading in May, a similar resolution would need to be considered by this board, as it is a similar but separate process.
Andrew, just I don't know if you were advancing the slide when you move into the next.
I'm going to right now, yeah.
Okay.
Just getting to that. Okay, so here's the Chapter 164 process. The first step is to adopt this resolution, and that institutes the conflict resolution procedure. The second step is to provide notice from the county administrator to the city administrative officer. That has to be done within 5 days. I've already drafted the letter. I think it's attached in your packet. That would be sent by the county administrator. The third step is a meeting between the city staff and county staff within 30 days of receipt of the first letter. It's sent by certified mail, and it has proposed dates and people in it. If there is no resolution after that joint meeting of staff, step 4 is a joint meeting of elected officials. That would be a joint meeting between the county commission and the city council, and the statute requires that be held within 50 days of receipt of the first letter. So that's the first letter that the county administrator sends, 50 days from that date. If there is no resolution at that stage, then either party may request mediation, although they don't have to. And then if there's no resolution, if a mediation is held, then the county is authorized to challenge the annexation ordinance by writ of cert in court within 30 days of failure to resolve the conflict. And then it would go through the normal writ cert process. There's the first phase, it's in blue. That's the area that is subject to this dispute resolution process today. You can see the second phase in like a greenish color. That would be a separate process that would occur in the future. We would bring it before you in the future if the city were to approve it on May 13th, 2024. And then just for reference, this is the red area is the urban service area. And that's it. That's my presentation for you. I'm here for any questions.
And there are questions. We'll start with Commissioner Gomez-Cordero.
Thank you, Mayor. I just wanted to motion for the resolution, please.
Second, Bonilla.
All right. We do have a motion and a second, although there are other questions or comments. I'll go to Commissioner Wilson.
Honestly, I think we've done, you all did a great job of communicating with us prior to this point, and I think it sounds like there's some definite momentum, so we're heading that way, so I don't want anyone to think I'm not. But I just wanted to clarify, so you said yesterday, because we had our briefing early yesterday, and that yesterday they included phase 2.
Yeah, yesterday they approved a different annexation, the phase 2, what they're calling phase 2, which was a voluntary annexation brought by the owners of the property, and they approved it unanimously.
So would we go through the same process all over again? We couldn't add that one to this one as part of a procedural prerequisite?
We'll add it at some point in time in the future.
Okay.
Yes.
Okay, that was that question. And then, I know that this was something that I brought up back when we talked about TDT. I'm going to reiterate it now as part of our overall approach. If we have been asked to be a regional partner in decision-making for investments in our area, we really need to make that something that is true across the board. And this is, to me, the biggest indication that that partnership is only good for when they want money, not for when the county is concerned about growth management and protecting our own residents in the future. Really quick question, and this may be something that can be resolved down the road, so I just wanted to ask if there was a spitball, but what this would cost our residents, knowing how much has already gone into and what the potential projections were in this area of entitlement. It's a spitball, I know, but
I don't know if anyone has any estimate with respect to costs. I can tell you that we'll be handling this in-house. The attorney's office will be handling it.
No, and I think not the house of us going through this procedural step, but the actual loss of the actual annexation and what that would mean.
Okay, so yeah, that's more
substantive.
Mr. Brooks.
You don't have to answer. If I'm putting you way on the spot, we'll go through it. This is going to be a process. Okay.
All right, Commissioner Bonilla.
No, I seconded it, that's all.
Okay. All right. With that, no further questions or comments. We do have a motion and a second. Motioner was Commissioner Gomez-Cordero. The seconder was Commissioner Bonilla.
And Mayor, just
yes.
broaden that to include the action requested. There's a little bit more in the action requested.
Okay. Bring the action up.
I can read it. The action requested is approval and execution of the resolution and authorization for the county administrator to take or arrange any and all actions deemed necessary to complete the dispute resolution process.
All right. If that's clear for the clerk, we have a motion and a second. All in favor, let it be known by saying aye.
Aye.
Opposed, no. The motion passes, and it is unanimous.
Thank you.
All right. Thank you, sir. We'll move to the commissioner's report. We are going to ask Commissioner Bonilla to present regarding the Lake Pickett Study Area Policy Amendments.
Thank you, Mayor. Here you go. So I'm not going to make a hour and 15-minute presentation on this because I've already done that. And we also already discussed this during the Transmittal Vision 2050 when I asked if we can remove this from Vision 2050, and staff said, yeah, if that application that was submitted at that time was denied, then the board can go ahead and move to do that. So in my memo, I did put in amendments for the comprehensive plan. I did speak to staff about it, that I will be recommending or asking for it to be removed from Vision 2050. I'm just going to say instead of the comp plan, because we're not making any amendments to the comp plan anyway. So I am going to go ahead and that's my request. It's very simple. I'd like to say thank you to Olin. I don't know if he's here he commended me on my amendments and said they were really thorough, and that I could probably become a planner now. But I think I'll pass on that. So I would like to make a motion if everyone's ready. We could move along for the afternoon.
You can try it. There you go.
All right, I so moved to move this forward to amend the Vision 2050.
All right, second.
Wait, so what is the motion? Can you be more specific in the motion?
To remove it from Vision 2050.
So it doesn't delay Vision 2050's adoption.
That's what it says. So that's second motion.
Thank you.
All right. All in favor, let it be known by saying aye.
Aye.
Opposed, no. All right, the motion passes and it is unanimous. And with that, those are the items for.
Mayor, I just have one thing that I just want to pass out, and maybe at the end of the meeting today discuss. It's from East Central Florida Regional Planning Council. I'm just going to pass it out for now so we could go eat.
Okay. All right. So with that, we'll come back at 2 p.m. for the BZA items. We'll reconvene at that time. We'll go into recess until then. All right. Thank you very much. Everyone, let me welcome all of you back from recess to April 23rd, 2024, Board of County Commission meeting. We're in the afternoon session, and we'll with our Board of Zoning recommendation. We'll start with Mr. Kozak, who's going to frame that. Mr. Kozak, recognize.
Thank you, Good afternoon, Commissioners. April the 4th, Board of Zoning adjourned 21 cases. 14 of those cases recommended for approval. VA 404-8, COVA 711 for denial. 6 cases of VA 25025, 24003, VA 24041, VA 40413, and VA 410, at 24014. They were all continued. ZA deadline was Friday, 9, and 1 case 240 for 11. The zoning division will be requesting that to be scheduled in the future. With the exception of the BZA Guild, we request to accept BZA actions and findings.
Thank you, Mr. Kozak. If we do not have, we have a motion. All right, we have a motion by Uribe, second by Ms. Cordero. All in favor, let it be saying aye. Aye. Opposed, no. Passes. Unanimous. Let the record reflect on Commissioner absent, and that is Michael Scott. With that, we'll move to the next item on our agenda this time. We'll for our hearings for the service units, and we are going to open the public and Dawkins, the MST advisor for special business, to frame this.
Good afternoon, County Commissioners. A1. This is from a developer established the Sherwood Unit 2 for street lighting and pond maintenance, which consists of lots. Street lighting assessment $230 per lot. Additional expenses and administrative. The retention pond maintenance assessment $78 per lot. Operational administrative. This subdivision is located in District. These establishments must be used for street lighting and maintenance effective November 2024.
All right, thank you. And this is an administration brought about staff. However, we put it up for any public. Do we have other public for this item?
Speakers for this item.
All right, with the public hearing, and we'll go to Commissioner Cordero with the potential motion.
Second, Bonilla.
All right, we have by Commissioner. All in favor, known by saying aye. Aye. Motion is unanimous, and President voted. Commissioner President. With that, into the next agenda, and this is item 2 for this item, and we'll open on this item, and Ms. Dawkins again will frame this.
A2. This requires a developer to amend the area MS for retention pond to add 96 lots of Hamlin Ridge, 3 lots of Hamlin Point. This will allow all 191 lots to be assessed for retention pond. The retention pond assessment will be $1 per lot for operations and administration. This area is in District. This amendment will be used for maintenance effective 2020 if approved today.
All right, thank you. And the members of the public heard on this item?
No speakers, ma'am.
All right, we'll close and we'll go to the district. Commissioner Wilson, would you like to offer potential? Okay, we have a motion and a second. In favor, let it be known by saying aye.
Aye.
Opposed? A motion passes and unanimous. We'll go to the A3 and we'll open the hearing on this item.
A request is from a to to amend the Stone Hills Pasture Roads for street lighting to include 50 lots of Foothills Mount Phase 4 A and B. Lighting assessment $52 per light, operational expenses and fees. This subdivision area in District 2, this amending for street lighting will be effective 1st, 24 if approved.
All right, thanks. Are the public who wish to be heard?
No speaker.
All right, close the public. Go to the district commission. More offer potential.
So moved.
Second voting.
All right. A second. All in favor, let it be known by aye.
Aye.
Opposed? And it is unanimous. That will go to 4. Another SBU. We'll open the public item. Ms. Dawkins.
A4, request is from to establish at Ovation MSB for street lighting and retention pond maintenance, which consists of 99 lots. Street lighting assessment will be $160 per operation and administrative. The pond maintenance $78 for operations and administrative fees. This subdivision is located in 1, establishing for street lighting and for retention will be effective November 2024 if approved today.
All right, thank you, Ms. Dawkins. Another administrative item. Are the members of the which should be heard on this item?
No item, Mayor.
Close the public hearing. The district commissioner, Commissioner Wilson.
So,
Uribe?
Motion and a second. All in favor, let it be aye. Opposed, no. Motion passes. Unanimous. And so we'll move to the item on our agenda. Another we'll hearing on this. A5, and Mr. will recognize.
A5, this request is from county utility the WICKE Drains Sewer Fit Program for MU. Construction of a gravity sewer system include Carlton, known as Reserve, Rolling 1, Rolling Unit 2, Rolling 3, Rolling Oaks 4. 96 ballots to property owners to determine majority of the ballot, approximately 75 in favor of the MS water system. These will be a period of 10 years, 6.6 interest rate. The estimated total cost per project for the project is $75 for an annual assessment amount of $1,055.57 for no expenses and amendment fees. Subdivision is located in District 2. Establishing MSBU. These water improvements will be November 2020 approved today.
All right, thank you, Dawkins. Another item, or public present who wishes to be heard. Item.
For this item, Mayor.
Close the public. We'll go to the district. Commissioner Moore to offer potential.
Yes, but it's Wakaiwa. Spring. Okay.
Thank
you. We have
second one.
All right. Motion and a second. In favor, let it be known by saying
Aye.
no. Motion passes and unanimous. With the next item on our is item 6. We'll open the hearing on this item. Dawkins, you recognize.
A6. This request county utility established Iowa's sewer retro phase 6 MSB. The construction gravity system to Majestic and Sweetwater Place. 3 ballots were owners, majority ballots returned. Approximately 90% were of the staff of the MSB. The waste improvement fees will be for 10 years 6.7 rate. The estimated total property owner would be $600 for an assessment of approximately $1,055.57. Operational and administrative fees. This subdivision is located in District. This establishing MOU for waste system improvement effective November 1st, 2024.
Dawkins, other administrative item, go to public presence item.
Mr. Mayor.
All right, we'll close the public to the district commission. And Commissioner, to offer a motion.
I move the recommendation.
Second, Wilson.
I have a motion and a second. We will let it be known by opposed, no. Motion passes, and it is unanimous. All right, next item on our item A7, the public hearing on that, Mr. Dawkins.
A7. This is from Partners. This item is developer establish the West Oak and MS street lighting and retention pond maintenance, which consists of 101 lots. Lighting assessment $4 for expenses and administrative fees. Retention pond maintenance assessment $78 for operational expenses and administrative fees. This subdivision is located. These establishments must be used for and retention ponds will be effective November 24 if approved.
All right, thank you. Members of the public press on this item.
No speaker.
All right, we'll close the hearing. We'll go to the district. Commissioner Wilson, would you like to offer petition?
Second.
All right, we have a motion. All in favor, let it be aye.
Aye.
No. And it is unanimous. And thank you, Mr. That was the last item for you. So we're going to move to B, and we'll open on this item. And Ms. Sack, our Deputy Director of Public Works, I'll frame this that you're recognized.
Mayor, to vacate PTV 3-01 from Gloria Sibley. The petition requests that Orange County a 4-foot wide, 20-foot easement that the west property for her residential lot in the subdivision, approximately 200 square feet. The property lies north of Billinghurst Place, of Billinghurst Court. The petitioner will vacate to clear the title to her property for future real estate management, roads and drainage, and environmental protection divisions have to this request. The petition to vacate was approved by BCC February 6, 2020. We heard due to an error. This request will have no adverse effect, and staff has no this request. Our request is approval of 23-5-8. The parcel is located in, and I'm here to answer any.
All right, thank you. Applicant on this item, would you like to offer any comments? Okay, she's here, but no comments. Thanks. The public present be heard on this item.
No speaker, Mayor.
All right, then we'll close the public hearing item. We'll go to Commissioner. Dave, would you like to offer
Yes, motion for approval of requested action.
We have a motion and a second. We'll let it be known by saying aye. Opposed, no. Motion passes, and it is unanimous. All right, with that, we'll move into the next. And this is item B, public hearing on. And again, with Susan, the Deputy Director, works to frame that you're recognizing.
This is a petition to vacate corrected 23-06 from Brittany Huff, Screening and Awning Inc. on behalf of Roger D. Miller. Request that Orange County approximately 5 feet wide portion of a utility easement that lies near the northern part of a lot located in Springs subdivision containing a 206 feet north of Pine Drive and east of Phillips Boulevard. The petitioner wishes to clear title of property for future development. The real estate and environmental conditions have no request. Utility provider provided letters of the petition to vacate was by BCC 620 is being reheard to an advertisement. Approval request will have no adverse effect on Orange County and staff to this request. All requests approval of corrected PTV 2306-023. Also is located in District 1, and I'm here to.
All right, thank you. With that, is our representative the applicant present, and if she'd like to come for any comment, she's waving no. That, do we have any public present who wish to be here?
No speakers, Mayor.
All right, then we'll close the hearing on this to the district commission. Would you like to offer?
Yes, I'll move requested action.
All right, we have Commissioner. All in favor, let it be known by saying aye. Opposed, no. Motion passes unanimous. Then we'll go to the next agenda and do CT this afternoon, the hearing, and
This is a petition PTV 20-09033 from Chris on behalf of Acquisition and East Place LLC. The petition requests that vacate a 25 wide unimproved right-of-way on Avenue along the East Pine right-of-way. The petitioner requests lots located within the Hanhurst containing approximately 9 acres. The property line street and east of Clark. Petitioner will vacate in order to add land to his property to development, management, protection, and transportation drainage divisions have no request. All utility providers have also provided action letters. Approval of this request will have an effect on Orange County and to this request. Requested action is approval 23-033. Also is located in District. I'm here to answer.
is the representative of the applicant on present? She's coming for this one.
Commissioners, we are here to answer questions that you all may have. I've mentioned 5-foot uninhabited right-of-way. Second 25 feet come from the homeowner to the east, and when they their lots, it was never located, so there's not a street. From the map, it dead end to also to the north. Answer any questions that you all may have.
Wilson, then if you will stay for a moment. Do we have a public present who wishes to be item?
Speaker card, Mayor. Burrell. For real? That side? Okay. Please state your name on the record, and then you'll have 3 minutes.
My name is John. I own properties that will be on this road. The picture is a little misleading. The picture yes.
State your name and address.
On Burrell, and own a home 1405 Avenue is the that is in view. That's the wrong picture. And I own a home on Rise, which is by. That's the wrong picture. Do you have the proper picture, sir?
We're on the next public.
Yeah.
C10.
They're trying to.
That's okay. If you can see the picture, if you top of the yellow, the third house down, and if you of the yellow, or that one house, I have a brand home right behind that. I have part of the new driveway. When they're looking at that, they're going to half of that road out and then go straight through. We already have a problem because there's a restaurant on the opposite street, overwhelming neighborhood. Cars are parking on the street everything to go that is on Wise Avenue. It's interrupting the neighborhood. The neighborhood arms right. You go on the opposite side, so that would be the new restaurant. Same owner that's these homes. Tonight it is not ambulance. That's my or a truck down Wide Avenue to get to the end. Parking on both to go to the Italian Kitchen, which is a restaurant. It's overwhelming the parking. And so we feel, friends with every one of the houses, have concern. 3 houses that are probably years old, and the road is a homes opposite. And heavily, there's a slight issue. Now, if you 25 towns into the grass, that yellow line in our home, that with drainage. And he's already taken trees before approved that we're in easement area. It no longer looks like it's all barren time. And so if there's 2.5 cars per home there, we already have a with the road. The corner down this way goes to Curry Ford. Already parked on that road. Get two-way traffic whatsoever. And so there'll be a problem with drainage. For 3 of those houses, the 9 house, the with the top of it, we're going to have a huge problem. I don't know where do they have a pond, any of the ruts, and a couple of neighbors here today, their biggest drainage, but their backyard already having slight, just because it's been there so everything is the road far above, and so what's in front of the restaurant is Orange County. In Orange County, and on they went ahead and did no all the way to come to our road. It's really a backed up.
So, Burrow, a moment, and we custom get the opportunity for any response. No.
Sir, I don't have.
Do we?
I do not have cards, so if you can.
It still went out. Yes, I did.
I did not get it. Please state your name and record, please.
We have. Okay, thank you.
Hall Jr. I College Park on Westmoreland, 2020. I worked downtown as a commercial broker for 9.3. My daughter, my grandson lived just north of property, and the whole area here, single homes. I'm very clear what the plans for this property, Yosemite property, city, be looking for storm utility water and sewer. That when you're picking 2/10 like they are, this abandonment to some exaction of some sort of land is probably worth $1,000. The yield comes to the west. It just seems to me that in there ought to be an.
All right, thank you for Mr. Hall. All right, back to the applicant for any comments.
Just as to an exaction, I don't think that you all or a request for abandonment. Once you are not going to this piece of property for which the use was dedicated to the county, which it was used for a road, then it reverts to the original owner who was later, which is why, for example, on the that came before, then ask those homeowners to pay you land. I know the neighbor has concerns about what's going on the east side of the property. Certainly forward with the development of parcel, there will be hearings to discuss kind of all of it. Today our request is limited to the abandonment. Since candidly I started this piece of property, it was clear I was using 25, and the worst thing we do is to leave as an abandoned 25 strip there that is kind of land is it or has control over going in that area. But questions you all may have.
All right. I don't have any other. I'm going to close the hearing. We'll go to Commissioner Uribe on this item.
This is staff. Things that concern me is that the effects. Learned of this earlier because I think there's lives there meeting to discuss this. Quite honestly, very set standard as a county would be requested, but by the time it's annexed into the so anything lose any kind of condition on this property, or I'm ready to motion, I would continue it for community meeting with the neighbors to really, and then also allow Ms. Wilson and to also. The biggest thing is what's going to happen there, and I think these owners at least that are this discussion. If you are agreeant, I want to continue, but I'm concerned about the date to establish a community meeting for notice. So our calendar looks like. And if you're able to do that, that would be fantastic.
Commissioner, the upcoming schedule, ability for community, team, or if your intention is to also, what may be a land use application, or to discuss what may be or via an application on, might want to be able to do some of that. Prepare that information.
And also, unfortunately, in May, enough community. So
our Commissioner, May 7th, May 20th, but it sounds like that may be too soon.
May, unfortunately, time in May may be early for a community, and then I'm quickly right after.
Right. So then in June, we have 4th and then 18th.
That's to give us some time to have the meeting. Okay. So with that, I would like a motion for continuance to June 18th at, please.
All right. We have a motion for continuance. All in favor saying aye. Aye. No. Motion passes and it's unanimous. So it will be afternoon of June sometime after 2 p.m. All right. We'll move to item. This is item 11 in the public. This item, and so you frame this item as well.
This is vacate PT 4-1-0 from Kelly on behalf of some. The request that Orange vacate a portion of a utility easement along the south line of his residence lot in Orange Club subdivision containing approximately 918.3. The property lies north Green Drive, west of Turkey Lake. The petition to vacate in order to clear title to his property. The real estate manager and environmental protection have no the request. Utility providers have letters of no. This request will have effect on Orange County. If has no objection to this request. Tested action is PTV 2401-00 and the parcels subject to 1. Questions?
Thank you. On this item, so we'll just come forward and comments? Okay, so he'll be available for any comments. So stand flat. Do we have a public present on this item?
Two speakers, Olden, Ron Olden. You want to go to the, you'll have 3 minutes. State your name and address for the record.
I'm Kathy Oldenkamp. I live at 6048 Shoreline Drive, which is just this parcel. Good afternoon, Mayor, Commissioner.
Afternoon.
And we're new. We are presently rebuilding a house in Orange, Southwest Orange County, Dr. Phillips, that has been destroyed by fire. As we build, Orange County disallowed some that we've asked for as allowed due to minimally setbacks for the impact of the new ordinance that requires extensive on-site drainage improvements. This is all understandable in the building process. There has been instances when we've done and subsequent understand that, but when neighbors and ask the county why do they have it, the response, well, they didn't get that permit. So they were here by the county commission to view our Mr. Klatz and to vacate a 5-foot easement between lots. Plat is apparently permitted, previously unpermitted pergola installed by him approximately 15 years ago. As it turns out, pergola not encroaches several feet, 1.5 side yard back. It reaches into a side yard easement, very for build. We have 2 questions, if I could just. Mr. Klatt, survey that supposedly shows not encroach utility, then why is it necessary to have a utility vacate? Second, Mr. Klatt did for a permit for until just recently. Shouldn't he be subject to the drainage ordinance they adopted in Orange County that he's subject to? Is he being allowed water on property? We are carrying here. Structure that Mr. Klatt is a building or was built close so that he has since block the flow of stormwater, push it into our. Is he getting treatment on this issue? As you can see, right here is the impacted on it, his grill are way too close. Thing. That's it. Any questions?
No questions at this time, so just stand by.
Thank you.
We'll go to the applicant at this. Any comments or comments?
Mr. Ron?
There were 2.
Oh.
Oh, sorry. So, Mr. Odin, you gave life, in other words. That's got that. All right, we'll go.
In regard to the information she just passed on, the county has cleared this. I've spoke to zoning as well. Home 7.5 from the property line for 5 foot. This has been over and over now. Was completed a certified survey was permitted or was where it shows this the 5 foot, I think it's 5 foot away from the property line. The rest of the street turns away from and goes. The other issue, I think it was something, it's not a drainage easement, it's a utility easement. The fall lights from the patio where this out was constructed, and mind you, it was, as she said, it was built years ago, and we had gotten HO relied on the promise, which we found. We consequently, in all permit, building and electrical, close those. We have a certificate of completion on that, so it's all properly permitted. The what I was saying was a fall from the to the lake 4 feet is all directly in toward, and it is at that time. There's 25 years. Kitchen's been there for. We have never flood, and we've gone through 7 years, and we've never waters out. Which is kind of ironic, not with about a gross square foot counting your garage thing. They were a 1,000-foot house. So be worried about them, but.
All right, Mr. Platt, stand by for. We'll go to the district. We'll close the public. The member of the public who should be heard. Close the public, and we'll go to the district. The commissioner would like to offer a motion, or do you have any?
Well, I would clarification if it works on potential about a petition to vacate cannot be a piece of right. It was from one parcel given to the county that's going back to that parcel.
Well, this is a utility completely on his.
Completely on. I think I had heard, in between the properties. I just wanted to make sure I understood that it was completely on your property. And because it's a utility, not a drainage easement, even though there's a legitimate concern, there's an opportunity for us to maybe talk about the way that they evaluate permitting. It would be this case, utility easement. So with that, I'll make a approval.
Second.
All right, we have a second. All normally saying aye. Opposed, no. Passes, and it's unanimous. Thank you. Those two residents present this afternoon. We are move forward. Agenda. We're going to move to item B12, and we'll hold a hearing on item. And we're going to ask Hall, our environmental program, to come forward with this item D12.
Thank you, and good afternoon, Mayor and Commissioner. Today I'm presenting an shoreline alteration and fill permit request Heinrich as applicant for a concrete block C. Here's the location map of the. It's located at 526 Lane, Windermere, on the canal, Lake Sawyer. The property are shaded in red. And here's an area of subject property. It's outlined. Canal at the there, and then of the shoreline condition they have completed, and then here is the applicant is authorized the 86 of replacement seawall now leading the lake. Staff determined when the existing seawall was constructed and no SAD is found in the files. However, photo of that was very dilapidated, and it was constructed to the applicant's property in 2022. Constructed the replacement immediately landward of the previously existing. There's a 6-foot return on the east end and on the northwest end, as there's an abutting on that neighboring property. Based on prior riprap and normally require replacement walls. Now, no additional planting required, so as a navigational concern. Section plan for the seawall. And then, as I mentioned, this is after the fact. enforcement history up through really. First of last, EPD staff observed being installed on the property, sediment and erosion in place, quality violations during. So we took some samples. Certified water results confirmed that a water was present. Of last happened in an enforcement case, a notice of violation. There was an penalty assessed of $1,900 on May 8th. The applicant submitted a permit application to EPD. The work. And 15th of this year, remitted a done through negotiation EPD $9,000 conservation trust. Some consideration. This project was reviewed in Chapter 33, Article 4, Section 129, criteria and conditions. We, the public within 500 feet of the site and received inspections. Finding is pursuant to County Code, Chapter 4. EPD is evaluated CDF permit and required documents. As made a request is consistent. 33-120 action request to the findings and recommendations of the staff of the after the fact shoreline operation dredging permit SA 3040 for review subject to conditions. Staff report. This is in District 1, and I'll just let you know that the applicant was unable to be, but she provided a statement says that UNRIC supports for permitting the seawall. They very professionally handled the permitting process. Sincerely, UNRIC. That concludes my presentation. Thank you, Mayor.
Thank you. Applicant could not be here. Check and see if any members of the wish to be heard on this.
No speakers on this.
All right. We'll close the public. Go to the district. Commissioner Wilson, would you like to offer your motion?
I'd like to move.
Second, Gomez.
All right. The second, Gomez Cordero. All in favor by saying aye. Opposed. Passes and unanimous. That then we'll move to the next agenda, and this is item 13. And we're hearing on them, and I'm going to call our Director of Public Works item.
Thank you, Mayor. Public 13, amendment to the Grand Cypress Resort. The overall is located between Vineland Road and Winter Garden Vineland. This request is to 18-acre on the Winter Garden frontage. The subject site was previously entitled 84 Resort Units and is to change to an 80 multi-family. The property is designated on the future land use and is entitled to is Grand Cypress Plan Development with an intent of multifamily other tourist uses. The aerial shows developed with a mix of uses, more resort up and off the north portion, left portion, the hatch of the parcel being considered. Here we have the plan with the affected parcel outline in red. It's small, but it's in the middle portion. Recommended action, finding of consent to comprehend and approve the Grand Resort Plan development subject to the conditions of the DRC and the staff report. Mayor and Commissioner briefed on this request. This case one is available for question.
Thank you, Mr. Is the item present? If so, come forward and offer any comments. He's thinking on making any comments, so please stand. Do we have members present who wish to be?
No speakers on this item.
We'll close the public and we'll go to the district. Commissioner Wilson, would you like to offer?
Second, Gomez.
All right, the second on Commissioner Uribe. All in favor by saying aye. Aye. Opposed, no. Motion passed, and it is That, we're going to go to this item on our this afternoon. This is item F14, and this is regarding to plan and small amendments. With that, I'm going to, we'll be opening 14 and D, open up the public hearing item, and ask Mr. Jason to come forward, our chief planner item.
All right, thank you, Mayor, Commissioners. This is a future land use amendment and a substantial change. The future land use from industrial to high-density residential housing, and the PD change is to change the designation for the parcel industrial and commercial uses. The 626 student heads, and this is for a project 313 North Alpha District 5. This request text amendment to future land use flu 8.4 to establish the maximum densities and intensities for. So this would establish for that parcel the 66 student beds. Located in District 5, this is an of the subject property on the east side of Bay Trail in Science Drive. This is a aerial text to the property. Again, the future currently industrial. Proposed future PD city residential student housing. Is our element. This is the land use the access to the parcel. There are 8 waivers associated with this. Is to increase the area from 6% to 75%. Waivers 2 through 4 are setbacks. West and south boundaries, it would be 25 feet. To setback would reduce from 15 feet and 5 from 15 feet. Waiver to increase building 5 feet to 80 feet. 6 is to separation that is from single family student housing, reduce it 400 feet to 8 feet. 7 is to reduce the parking from 1 to 0.9 space per bedroom. Bicycle parking space located greater than away from the entrance. 492 notices were sent extending beyond 800 feet from the subject. To date, we have any responses. The committee meeting was September 9, 2023 with 3 attendants. They support the request. Planning and Zoning Commission. There were the Planning and Zoning Agency is recommended to make a finding with the plan and approve the and text amendment. Development Review recommending approval of PD substantial subject to 22 approval, including the 8 waivers of Orange County Code. And staff is available.
All right, thank you. Is the applicant representative present? Ms. Wilson coming forward.
Commissioners, on behalf of the applicant and staff report to answer questions, I did want to add, I believe, one additional condition of approval to make sure it made it conditions related to
a proportionate share coming back at the you are concurrent with the DP. Mr. Sorensen, I think he's trying to put ahead.
So we agree with it to be added.
Okay.
Just for clarity, that would be condition of approval number 20, and then 22 would be 23.
All right. With that, do the public to be heard on this?
No speakers there.
So, the public hearing time. District Commissioner Bonilla offer motion.
Did you have the Nick said that you had a plan that you go and mention about the
Sure. provided, if you want to see specifically Alafaya. Yeah. So this is just sections of Alafaya. So there is a 5-foot 4-inch landscape, 10-foot side, and then 2 inches of landscape. So the right of way is enough there for us to be able to accommodate that.
Just go back to your mic, please. Or
I'm sorry.
We just missed okay. Audio.
I can't. It's a 5 landscape, 10 feet of side, and then a little over 7 feet of landscape, and have for development. And I believe that's what Jason has. That has our full land plan around that, consistent with what we're showing.
Okay, thank you.
And by the way, the development plans back here. At the time you have another verify that we've put a buffer.
Thank you. I'd like to make a motion with the addition.
Count Wilson.
All right, the second Commissioner Wilson. All in favor of saying aye.
Aye.
Opposed, no. Motion passed, and it is.
Thank you.
All right, thank you, Ms. Wilson. All right, we will. The next item on our, and this is item that is on our, and item G15, the public hearing on this. I'm going to ask Burnham, the attorney, to frame that much comment this morning centered around adult entertainment management. With that, I'm going to bring the item in question.
Thank you, Mayor and Commissioners. As you know, this relates to that discussed earlier, but the item at issue is an ordinance to amend certain portions of Chapter of the Orange County Code. 3 is with the Adult Entertainment Code. Implementation may be a. The proposed amendment issue are to Article 2 of Chapter 3. It'll be the little roadmap, although it's a fairly presentation. Background, talk about ordinance, the proposed ordinance, and then requested action. Heard a little bit this morning through a quick for anyone an adult establishment in Orange. The person entertainment, the person or entity, I should say. Chapter 3, adult entertainment governs the process for obtaining the license and information. Adult entertainment license is issued by the Orange tax collector pursuant to the Adult Entertainment Code. In practice, the licensee can be the owner itself, or it may be a person other than the owner, such as a tenant. Bill talking about the current code provides a licensee if that adult license is revoked by the holder gets of that action and an opportunity to challenge the revocation. Adult entertainment provides current form, and talked about a little bit, is no an opportunity revocation to property owners also licensing. Despite notice to where there are some adult codes that impact the owner. One, if an adult is revoked, is from being used as an or adult entertainment for one, and if the establishment existed as a non-conforming prior to the non-conforming use terminated thereafter. So the provision under current ordinance actually get into the reasons proposed and the amendments that are being presented for your consideration are to provide the owner with the process type safeguards that a licensee has. And those are the no opportunity to challenge, the revocation, adult entertainment. Proposed specifically to the sections of the code that are section 35, titled suspension, 3 titled revocation, and 337 challenge of a suspension notification and determination by a hearing. The entire proposal you have of it's been, and the public has a right to. I put up here just an example that exemplifies what the do. One is -30 subsection 6, which governs revocation, convictions of or violations of the operator of the establishment. You can see on this provisions in red line are the proposed. So here, where certain crimes or convictions, licensee of a revocation and subject to the licensee's right to file a timely change under 3-7, the would notify the licensee and the owner, and the licensee owner would right to file a timely challenge. So the proposed again are to ensure the licensee and a proper if that or person in the licensee of the same words related to an adult entertainment license and to ensure the adult entertainment code. Requested is approval of ordinance amendment county adult entertainment code codified by amendment section 3-30 and 37 to provide a date for. Thank you. That's all I have.
All right. Talked about all of this, Commissioner Uribe.
I just have a question of clarity. Having our discussion and these being put in actually don't affect any of the current licenses. This would be moved. Clarify that?
Well, I mean, it would be Commission.
So earlier it was alluded to that have it now could essentially, but this is really only forward, not proactive.
Right. Okay, correct. Effective, this ordinance approved by the board is effective. Then moving forward, the tax code would follow the amended provision, providing not just the licensed property owner.
All right. This is an item primarily for by members of the public who wish to.
No speakers for this.
Right. With that, was the public time. I'm going to move a requested action. Second, Commissioner Wilson. All in favor, let it be aye. Opposed, no. Motion is and it is unanimous. All right. We do not have a scheduled agenda this afternoon. Bonilla out something early. It's an agenda item. It's not appropriate for us to take action on it. However, she will share this information with you. That has come to attention, I think, East Central Florida Regional Planning. With that, a few moments, Commissioner.
So given by the East Central Florida Council, better support through the of all this. Sorry, the legislator going to looking for appropriation and appropriations, looking for letters from these. They're asking for this as possible. I think we'll be able to get a board approve to get this, we could do individual and a letter of support if we can't board.
Approach as just to weigh in on, but we would to have had an agenda if we were going to take action and then look about sometimes weighing in congressional matters. We could, I think, as a local body, we try to deepen what we do.
Bill.
Is that when congressional matters to use that in Washington before Congress, and they can be very bipartisan, but become very, very and in D.C. just as a caution to our say to we can body, we be real careful. Even so, decide to do that. The board members have adequate notice, and so that due diligence and research the matters. And I look at this and on the surface it would seem fair, but Congress when appropriate, it's a given because strong partisan issues that within D.C. and some seem even simple is in Washington. We didn't have the benefit of even the national counties and are not certainly the Florida Regional Council. I support our regional planning for what they do, but I think more appropriate the body weigh in on these issues as individual capacity for such just about it, but because it's not an action on it. But
all right, thank you. Well, here's information. Office did return earlier. I on the agenda, but get answers back quick. So, we all always go either the state or the federal government that are important to each of us to do that if you wish to your own letter of
support. We do not have a matter body this afternoon. Thank you all very much.